authority list, fresh admission item number 1.
May I please, Lords? Let this annexure fee is impugned. It's a regulation amendment of a regulation made by the RERA, but the power is not available anymore with the said authority. It's fully without jurisdiction and a nullity. Your Lordship, I have given a short note. Before amendment, it was with RERA, but that power has been taken out from RERA and has been conferred with the government. Section 84 is the rule-making power. Your Lordship may kindly look at section power of appropriate government to make rules. In particular, this is pre-amendment. And without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely, information and documents for application to the authority for registration under clause aim of subsection 2 of section 4. That deals with the application for registration. Post-amendment, that this power of appropriate government, in particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely, the firm, time, and manner of making application and fees payable therewith. That we are concerned. This power is now conferred with the state government under the rule-making power under section 84 of the Act. And AB also inserted. This was earlier not there.
What is the actual height, sir? What was it earlier and what is it now?
Earlier, Milord, it was this part 4. They have taken it. I think that was 10 rupees all over the country. In Delhi also, that is the 10 rupee. So now they have amended, but this notification, Milord, without any power.
No. What is the difference?
But that difference, your Lordship would find it from Rule 4, Regulation 4, I'm sorry, Milord, that the old Regulation 2017. Application made under subsection 1 of section 4 shall be accompanied by a fee specified in the table below. Type of projects, if it is residential, then per 500 square meter up to 500, 5 rupees subject to maximum of 2,50,000 rupees. Commercial project, 10 rupees subject to a maximum
So from
of
10
5
it has
lakhs.
gone to 200.
That has gone to 200.
No, but when was that earlier rate fixed?
17, Milord?
2017.
17.
So in 5 years, they've increased it this much.
That is correct, Milord. But
No, you
the
are saying only
question
the
is
government
whether
can
it
do
is yes. With the whether the RERA will do or the government, it's a nullity, Milord. Your Lordship knows the Kerala State Electricity Board case is the 2022 recent judgment, which takes care of.
All right.
It is a nullity.
The challenge in the present, the challenge in the present petition is to the Odisha Real Estate Regulatory Authority (amendment) regulations 2022 notified by the Odisha Real Estate Regulatory Authority on 28th July 2022, enhancing the application fees under para 4(1) of the Odisha Real Estate Regulatory Authority regulations 2017 regulations, ORERA regulations, ORERA regulations whereby the rate earlier fixed, for instance, for a commercial project has been enhanced from rupees 10 per square meter to rupees 200 per square meter of the total land area, subject to a maximum of rupees 1 crore.
But the entire thing they have revised. Even the
for instance, I've said.
Yes.
First, the ground among the grounds on which the challenge is raised is that under the in terms of an amendment to section 84 of the you're not challenging that amendment.
Yes, Milord. That is the impugnant.
No. This notification doesn't amend section 84, sir.
Yes, Milord. Even 84, 85 both. I have given a Milord short note, 1-2 pages. Your Lordship can kindly peruse. What was the pre-amendment? What is the post?
No. Amendment by which? See, this is the regulation thing which enhances the fees.
Yes, Milord. That is under challenge.
No. The section 84 amendment by what?
Milord, section 84 has been amended. Earlier, the power was under 85. 85 has been deleted. Your Lordship can kindly see the next 85.
No.
Page 2.
My question to you is something else, sir. The note you've given,
yes,
you've shown me the pre-amended 84 and the post-amended 84.
And 85 also. Next page.
Right. Now, these
85 million, this power has been deleted.
Amended by what, sir? This is amended by what?
Amended by Annexure 3 million.
Annexure?
3 million, page 30 to 33. I have given that notification also. Your Lordship may kindly look at page 32. Page Miller 33. This power is with the central government, section 91. Section 4, this subsection 1 for a word specified by the regulations is the word prescribed.
But in your prayer clause, you have not challenged this. Just look at your prayer clause. You have not challenged this.
No, I have challenged that notification. By the impugned notification bearing numbers 1 so high, Annexure 2 shall not be quashed being on.
No, Annexure 2 alone you've challenged, sir. You have not challenged Annexure 3.
No, 3 need not be. I am relying upon 3 million. 3 they, your Lordship may. Earlier the power was with the RERA authority under section 85. 85 has been omitted. That provision, your Lordship may kindly again look at this statute. That your Lordship may kindly look at this. This notification is in my favor, Miller. 3. Your Lordship may look at the book. Miller, this Annexure 3 in exercise of power under section 91 of the Act, RERA Act, this central government, that is the power to remove difficulty. They amended this. Miller, that this, your Lordship may kindly 3 sections they amended. In section 84, in subsection 2, the following clause A, the clauses shall be omitted. Substituted. Miller, earlier, the firm, time and manner of making application and fees payable therewith under subsection 1 of section 4, information, etc., etc. Your Lordship, in section 85, your Lordship may see Roman 4. In subsection 2, clauses A, B, and G shall be omitted. So this is, Miller, in my favor. I am relying upon this. By your Lordship may look at the book, the professional book. But that amendment is there in the new book. Your Lordship may look at page section 84, Lordship said. In particular, this is the rule-making power of the government.
Of the appropriate government.
Of the government means state government. They have invoked power under 85. It is no more there. Next page, power to make regulation. The authority shall, within a period of 3 months of this, this 2AB, clause AB omitted by 28/10/2000. This same notification. This was earlier available with the authority under the regulation making power. They omitted it and conferred it on state government. The same clause that has been inserted in 84. That note will clarify. You Lordship may the
all right.
2 pages.
See, the contention is that
earlier power was with the government.
After the amendment,
yes.
The contention is that after the amendment to section 84 of the Real Estate Regulation Development Act 2016, which was notified by the Ministry of Housing and Urban Poverty Alleviation, Government of India.
That is my
by an order dated 28 October 2016. Power to make rules in relation to fees payable along with an application for registration has now been taken away from the ORERA and vested in the single quotes appropriate government, unquote, which in this case would be the government of Odisha. Stop. It is accordingly contended that the impugned notification dated 28 July 2022 is beyond the competence of the ORERA and therefore is bad on that score. You say notice, Mr. D.K. Mani, Additional Government Advocate, accepts notice on behalf of opposite parties 1 and 2. I think Mr. Tripathi usually accepts notice for Mr. B.B. Tripathi Learned Council accepts notice for ORERA. Replies we filed within
কপিটা দিয়ে দেবেন।
I'll serve a copy on Mr.
Six
Tripathi.
We will
weeks.
serve a copy
Yeah,
on VP
yes,
Tripathi.
Yeah. 6 weeks and rejoinder for the next date. Then in this application for stay, you say all payments made hereafter by the petitioner. Petitioners, is it?
Association.
By the members of the
Members of the petitioner.
petitioner association, along with the applications filed by them in terms of the notification dated 28 July 2022 will be kept in a separate account.
That Orera
No, that
is
is
direction is Orera,
No,
not.
just a minute.
Kept in a
But
separate
that is,
account
Milord,
and will be subject to the
Milord,
outcome
it's
of the
nullity. It's Milord, absolutely it's void.
be kept in a separate
No,
account.
It's
it will-
exorbitant also, Milord.
No, no,
Apart
so
from
that it will just be returned, sir.
No, that
so
is
once we
correct.
say keep it in a separate account, there should be no
No, but
problem. for
we'll pay, go on paying as per the prevailing, Milord, the four.
No.
Milord, this amendment is, your lordship may kindly appreciate. Milord, if a notification is fully without jurisdiction and authority,
See, you're
they
coming-
don't have any power to levy the
See,
fees.
already since July, with all your applications, you must have already been.
No,
paid.
Milord, it was not within anybody's knowledge. They had kept when we represented them, they realized it's wrong. So you lordship may stay it. Let it come any date,
See,
Milord. But it's void, it's
kept in a
nullity.
separate account, which will be interest bearing.
Milord, may I pray
Milord,
that it's 200 times, Milord. Sorry, 20 times higher.
That's all.
So you
will
lordship,
anyway
but
pass on the
50
cost.
lakhs, no, it's only a registration fee, Milord.
Yeah.
All over the country, the 10%, Milord.
All
All over the country.
All
So, Milord, what I pray, Milord, your lordship may kindly consider, subject to your lordships,
Yes.
we'll go on paying the same rate. It is not, I'm not, Milord, that is also without nullity.
Correct.
If I go to the genesis, the existing provision is also without any authority.
All right.
So therefore, your lordship may kindly consider.
Yes.
So, or short date, your lordship may say, let it be disposed of. I'll serve a copy, your
See,
lordship
the
may fix
members
any
of-
date.
This is Credai Orissa Private Limited. Just see this.
Yes,
It's not
a-
an association, sir.
No, it's the company they have formed.
So only the petitioner then. Any
Wait.
amount paid is only particular to this
No,
petitioner.
all are members, Milord. All
Who's
are,
members? Members of what?
no, they have given it a
They have-
nomenclature. No,
They have
this-
constituted a company.
Yes, no, all of them, Milord, all of them, they have given it a name, registered like Bhubaneswar Club. Anybody can be a, Bhubaneswar Club is also
No,
a company,
once it's
Milord.
Private limited, it's just one entity.
No, your lordship may kindly, even if they can, if they are all shareholders. Bhubaneswar Club is also registered under the 1950s
No,
Companies
I don't know
Act.
whether it works on the
Your
same
lordship,
principles.
yes.
Because when you make an application, you will not be making application in the name of this petition number one.
No, Credai is all represented, Milord. This, they have different chapters. Orissa chapter, they have registered it and I was also inquiring that. How can it be? They say it
No,
is.
once it's a private limited, see, association is different.
No,
When you have
that's-
members of an association, then you say all members of this association will get the same benefit. Once you constitute as a private limited company.
No, they can be shareholders, Milord, your lordship.
No, no,
Anybody
but
can be a shareholder. So, no, that
shareholder
is
not
how-
the same. Shareholder is not the same.
The company, Milord, so far my knowledge goes, this Bhubaneswar Club is also registered under the Companies Act. They can also do it. It's not, Milord, it's all
No,
business
then
bodies.
See that
So, Milord,
what entity you form will have a bearing on this, sir. Because this private limited company, will it be making any application? I don't think it will be making any application.
no, that is what, no,
Company
they,
never applicant.
This Credai Private Limited is not going to be making any application. Somebody who's a shareholder there will be making that application.
no, that is true, Milord, but anybody who forms a, contributes and becomes a shareholder, Milord, he can own a share in the company. That is what they have been doing, Milord, since the inception. That is not, that is being recognized also by them. They represent and they are represented before various authorities. So that is not the issue, Milord. I will satisfy on that. But the question is the interim application which I pressed, Milord. Your
Yeah,
lordship.
because you have not made any
it's-
application, sir. You are even in fact not going to make an application. This Anil Agarwal also is an individual. He's a secretary of this association.
No, he is
will-
also a promoter, Milord. No,
No, but
Anil
he's also
Agarwal,
not going to make an application. So who will make an application? A builder will make an application.
a promoter, Milord?
All right. Or a builder.
Yes,
Right. So,
builder, same.
So they, by becoming a shareholder here, I don't know how they can get the same benefit.
No, but shareholder, individual, Credai doesn't apply, Milord. Individual, your lordship is correct. Individual promoter will apply. All the promoters are being, Milord, represented through this association which they have formed. Maybe
That's the
they have
problem,
given
sir.
it,
If it is an
they have
association,
registered.
Say if it's an association, you're right. This is a private limited
No,
company.
private limited company also, your lordship, I will cite many bodies, my lord, wherever they can also make it for profit or loss.
Then it will be a
So-
separate question, sir. I don't know if you want to go into all that, then we can't.
No, but my lord, your lordship may confine it to Anil Agrawal. Your lordship, he is also a promoter. He says.
No. He will never be
No,
applying in his
your
individual
lordship
name, sir.
kindly- no, that is I will satisfy, but he is also a promoter, my lord, petitioner number 2. He is also a promoter, my lord.
Is he going to make an application? You tell me which application.
My
he
lord,
will
I am not, anybody can apply under, it's a general law.
make. This is not.
Application will be made by a promoter. My lord, that is not in dispute. A CREDAI will not, the association will go and make the application. Every individual promoter has to go and make an application for the purpose of registration under section 4. So whosoever is making an application, he is not required under this regulation 4 to submit a fee. So whether that authorization or the regulation which they have made in perpetrated exercise of power under 85, my lord, if that power is not available for the RERA, anybody can question it. I am a promoter also, my
We
lord.
are entertaining. We are now under interim relief. As far as the main challenge is concerned, notice has already been issued. There's no
Correct.
difficulty. Anybody can challenge, you said, fine. No
Anybody.
problem. No problem.
Yes.
But we are on that interim relief part, right?
So interim relief part, my lord, why I am
Neither
saying-
petition number 1, and from what I gather so far, neither petition number 1 or petition number 2 are going to make any applications in their individual capacity.
No, petitioner number 2 is, my lord, is a promoter. He will make an application in the individual
Whenever
case.
he
That is
makes
what I am
it,
submitting.
Has he made an application or is he going to make
No,
an application?
whenever, my lord, this,
We can't.
my lord, everybody
indeterminate-
can.
It's
my lord,
like taking an advance protection and saying,
no, I am, my lord, I am a continuing
Whenever-
from builder, my lord. I have projects. I will apply also, my lord.
when will you apply, sir?
My
Don't
lord,
tell me.
my lord, any moment I will apply.
All right.
That is
In-
subject
okay.
to.
All right. Now listen to the order. IA number so and so. You say it is seen that petition number 1 is a private limited company. Mr. Acharya, senior counsel for the petitioners, explains that in this private limited company, there are many individual shareholders who happen to be promoters of real estate projects or builders. Full stop. He accordingly submits that any benefit from the interim relief prayed for in the present application should inure to the benefit of such individual shareholders. Paragraph, inasmuch as petition number 1 is not a single court's association of persons, unquote. The court, there is a question arises whether any interim relief granted can inure to the benefit of the shareholders of such a private limited company. Full stop. Mr. Acharya states that he will examine this issue and address arguments separately. Petition number 2 is an individual who according to
Promoter.
Mr. Acharya is himself a promoter of real estate projects. Full stop. When asked whether he has any specific application made by him or to any application to be made by him under the impugned under the RERA Act as well as the impugned notification, Mr. Acharya states that there is a possibility that he might apply in future as a promoter.
Not possibility. His ongoing projects, I may apply tomorrow also.
For any of his ongoing projects as promoter. Paragraph. It is clarified if petition number 2 hereafter applies under the RERA Act read with the impugned notification for registration of any project. The fees paid by petition number 2 in terms of the said notification will be kept in a separate account by the ORERA and will be subject to the final outcome of the present petition.
That is, that can it be, so that interest bearing, your lordship said. Interest bearing.
So
your
he will
lordship.
pay some, how much, some 1 lakh rupees or
No,
something?
no, my lord, it's 50 lakhs. That is the problem.
In an interest bearing account. All right.
Yes.
And will be subject. All right. All right.
Item number 2.
May I please your lordship? But here.
20th July, 20 July.
Item 2, sir.
But in terms of your law order, 9/1/2023, the 7th June 2018, resolution has not been provided in the compliance affidavit. I have collected it. I have prepared a small affidavit, which I will submit it in the course of the day. Your lordship may take it up any other convenient day. Any other day.
All right. A request is made. This is item 2, no?
Item 2, sir.
Your name doesn't figure in the cause list.
But I am submitting on behalf of Mr. H.M. Thoda, Harmon Thoda. I will be maybe permitted.
I see.
He is
Oh,
in-
appellant.
Appellant.
Ah. All right. The request is made on behalf of the counsel for the appellant that they will submit a written note of submissions
Written notice of I am prepared an affidavit also. Affidavit.
and a further affidavit. And then you say that the appellants will see that they seek leave to file an additional affidavit and separately a written note of submissions. Full stop. These be filed within 4 weeks with advance copy to counsel for the opposite parties, for the respondents. You're on behalf of both the appellants.
No. There is a cross appeal which has been filed at a much
second one
later
was
stage,
filed
which has not
by-
been admitted. It has not been admitted.
You say
Six.
appellant in WA
Both
number
have not
313
been
of 2020. You say list on 20th July. Along with this 191. And in 191, you say list along with that. Right. All right.
Item number 3.
Now, this is the.
Well, it's item number 3 and item number 17, my lords. I place similar orders as passed in yesterday's item number 28 in writ appeal number 689 of 2022, my lords. Your lordship,
What is that order?
your lordship has remitted back the matter to the single judge.
Ah,
But same dates and same, since the matter is similar, my lords.
all right. Same order.
Grateful.
Item number 4.
4 is my lord promotion. During vigilance case, I will take notice, my lord.
No, date.
Now, my lord is 11/5. 11/5, my lord. On 27/3, my lord fixed. 11/5.
11 July or 11 May?
July.
I thought 11 July, sir. You don't have even one of the orders of similar matters.
My lord,
We've been passing so many orders. You should have at least one, sir.
I will get one.
We just pass it over. You please get it.
Right.
Sir, at least the least you can do, so many appeals of yours every day we are passing orders and you don't keep copies.
I will provide.
Don't expect us to remember offhand like this, sir. It's too much of a burden. I don't know, you may be able to remember, but for us, I think we are getting very old. You have to excuse us.
I'm sorry,
Yes.
ma'am.
Yes.
Item 4 fast.
Ah.
Item number 5.
5 is Sarath Prada 8/5, ma'am. Take notice and return.
Item number 6.
Item 621, outsourcing DO, your lordship written on 8th August.
So far item number 6 is concerned, my lord, let notice be issued, my lords.
Yeah,
Let-
But
notice
I
has
will
been
serve
issued.
copy. I will
Yes,
serve
sir.
copy.
Notice all that. 8th August.
8th
is when
August.
it's- yeah.
Item number 7.
In item
Seven
number
is-
7, I am appearing on behalf of the respondents, my lord. Here in this case, the honorable single judge are directed to consider our case in light of Umadevi judgment. They may, if I have, we all are not covered under this judgment, they may reject, my lord. Only
No.
direction is to consider, my
All
lord.
this is the first day, sir. This is the whole problem.
No, notice has been a tribunal matter, my lord.
But has the order discussed the pleadings? If the
Is it-
order does not discuss the pleadings, then there's a problem, sir. The whole problem is that there's no discussion of pleadings.
Remand matter.
You see, it is seen that all the pleadings were complete in the petition before the Orissa Administrative Tribunal, which then stood transferred to this court. When it was heard by the learned single judge, it was disposed of on the very first day without discussing any of the pleadings in the matter. Full stop. This is significant in light of the contention of the appellant state that the case of the respondent is not covered by the decisions mentioned in the impugned order. For the aforementioned reasons, the impugned order is hereby set aside and writ petition civil OAC number 4832 of 2016, which was remanded to the roster bench of the single judge for hearing on 1st August 2023. The appellant will file its, since the pleadings are already complete, the learned single judge is requested to proceed in the
this
hearing
case,
of the case.
Counter has not been filed.
Sorry,
Counter has not been filed by the appellant.
even before the OAT.
Even before it.
You're waiting for the whole order to get dictated. When I asked you, were pleadings complete? You said before the OAT it was complete. You just now told me before the OAT it was complete.
Well, is it the matter arising?
You're waiting for me to dictate the whole order.
Sorry, ma'am.
When I'm completing the order, very quietly you're saying no counter was filed. He told us, no, the pleadings were complete before the OAT.
Sorry, madam. No counter has been. Sorry, madam.
Most unfortunate. Let's take off this whole, the first paragraph. You see, it is seen that the impugned order has been passed on the very first day of hearing of the writ petition. When in fact, when in fact no counter affidavit had been filed in the said writ petition, either before the Odisha Administrative Tribunal, where it was first pending as an OA, or in the writ petition which was registered after the said OA was transferred to this court. This is significant in view of the stand of the appellant state that the decisions cited in the impugned order do not cover the case of the respondents. Paragraph. You say for the aforementioned reasons, the impugned order is set aside, and then all that. Then you say the state will file its parawise reply to the writ petition on or before 17th July, and the respondents, that is the writ petitioners, will file their rejoinder on or before 1st August.
Pardon, madam.
No further time will be granted to either party for that purpose.
Pardon, my lord, there was an interim order in the writ petition. Status quo of the applicants,
All right.
respondents
Yeah.
shall be maintained.
Till then, status quo shall be maintained. You see, the learned single judge is requested to proceed with the hearing of the writ petition on merits and dispose it of as expeditiously as possible. Status quo as on date shall be maintained till then.
Oblige, madam.
The writ appeal is disposed of in the above terms.
Item number 8.
May I proceed? The issue before the honorable single judge was whether private school enjoyed the grant need for 20 years, my lord, from 1974 to 1994. When the question of taking over the school by the government came, my lord, the private management requested the government to hand over the management school to private body, my lord. That is HAL. In Annex 5, page 23, government accorded permission. If management will be, the school will be managed by the HAL authorities, then the government has no objection, my lord. But after now, government HAL formed a society. The society, my lord, manage the school. That is the object of whether once enjoyed granting for 20 years, can it be reverted back to a private body? The honorable single judge dismissed on relying upon a decision of the Supreme Court, my lord, page 45, paragraph 10 of the judgment, my lord, which is not applicable to. The question was once enjoyed granted for 20 years, can it be reverted back to a private?
Counsel for the appellant states that the question before the learned single judge was whether after benefiting from the grant in aid allowed to it by the state government, allowed to the school run by the Hindustan Aeronautics Limited, bracket HAL, can such private school decide to revert to being a non-grant-in-aid school to the detriment of its employees? Question mark. He submits that the decision in state of UP versus principal Abhayanandan Inter College 2021 SEC Online SC 807 is distinguishable in its applicability to the facts of the present case. Paragraph is a notice. Mr. Kuntia accepts notice on behalf of respondents. Respondent number 5. Notice will issue to the Union of India, I think, which is to say Mr. Pade accepts notice on behalf of opposite party number respondent number 4. Notice to the other respondents by registered speed posts made returnable on the next date. 20th July.
Item number 9.
Yeah. In a common judgment, your lordship already disposed of one appeal. Your lordship arising out of in a common judgment, my lordship.
All right. In view of the judgment dated 24th March 2023, in writ appeal 1408 of 2022, bracket Devendra Ram, Union of India and others, bracket. The present writ appeal is also disposed of, leaving the questions of law arising from the appeal open for consideration in some other case.
Obliged.
I am for the opposite participant.
Item number 10.
Item 10, my lord. In this case, I am challenging the learned single judge order, my lord, dated 3/2/2023, my lord, in which the honorable court was directed to file and review, my lord. This order, the main case is that, my lord, I am challenging the removal order passed by the opposite parties, which was communicated on 9/11/2012, my lord, by the order of the governor. Commissioner cum secretary has passed the order, my lord. Main case is that, my lord, while I was continuing as assistant professor, my lord, at VSS Medical College, a set of charges was filed against me on 24/2/2001, my lord, page 29, my lord, page 29, in which, my lord, charges was framed is at page 30, my lord. No document, no relied upon document, no witnesses was cited in the charge memo, my lord. Thereafter, I filed a...
No. Did you file a review pursuant to the...
No, my lord.
Why don't you avail that?
My lord, review is... My lord, appeal is not maintainable, my lord.
No. You asked to file a review.
After 31, my lord, rule 31 says, my lord, 21, my lord, the order made by the governor not appealable. If the appeal is not maintainable, appeal is not, my lord, I have not filed any appeal, my lord. But the learned single judge directed me to file a review, my lord.
So why is a review?
If the order is passed by the honorable governor, my lord, then as per rule 21, the appeal is not maintainable, my lord. No provision, my lord.
Why are you confusing between review and appeal? I don't understand. Nobody asked you to file an appeal.
Well, if appeal is not...
What has that to do with filing a review?
My lord, I have dismissed from service in the year 2014, my lord.
All right.
The case is pending before the learned tribunal. Thereafter, it was transferred to this honorable High Court.
All right.
After the proceeding is the year of 2001, my lord.
All right.
In the meantime, I have...
No. What is the prejudice? Suppose the High Court is permitting you to file a review before the governor. What is the problem that you face?
If there is no provision for appeal, my lord, then...
Why are you confusing again and again between appeal and review, sir? I don't understand. Nobody's asked you to file an appeal. What is the prejudice that is being caused to you because of the impugned order which permits you to file a review? What is the prejudice? All right. The impugned order of the learned single judge has permitted the appellant to file a review application before the governor against the order of punishment. Stop. It has been made time bound. Consequently, the appellant is unable to explain to the court what prejudice is being caused to the appellant as a result of the impugned order. So, consequently, the court is unable to find any reason to interfere with it. Nevertheless, the time for the appellant to make the review application is extended by 2 weeks from today. And if it is so filed, it shall be entertained and decided on merits by the governor, by the Honorable Governor, as stated in the impugned order of the learned single judge. The appeal is disposed of the above terms.
Item number 11.
My lord, grant me for 1 month time for file living.
You just heard the dictation, sir. You couldn't hear the dictation.
No, my lord.
I'll ask the steno to read it out because it will be too much for me to again dictate the whole orders. Just listen to him carefully. We have given you 2 more weeks from today to file a review. If you file it within 2 weeks, the governor will decide it.
My lord, instead of 2 weeks, 4 weeks, my lord. He's
No, no.
staying at Delhi, my lord.
It's all right. These days, everything can be done even by email. Not a
My
difficult.
lord, sign he.
Sorry, sir. Sorry. Yes.
Item 11.
May I please, your lordship. The appellant being agreed with the order of honorable single judge on Annexure 7 making disposal of the writ petition on the ground that it has become infructuous on the basis that he has made submission to that effect. He has filed the present appeal because this case has never become infructuous and he has never made any submission to that effect. And the counter was filed, the case was ready for hearing, and this petition was ready for making argument on the merit of the case for disposal because it was filed in the year 2017 in the tribunal, and upon abolition of the tribunal, the case was transferred to High Court and it was ready for adjudication. The petition has a well made out case for relief, my lord. This petitioner, who was a candidate for Orissa Civil Service Examination 2015, qualified in the preliminary test, written test, and appeared before the viability test. And after publication of a result of a viability test in the year 2017, he found that he is running short of 48 mark for being finally selected as a unreserved category candidate. When answer scripts were obtained by him, and he found that all his answers are found correct, and everywhere they have given trick mark, but they have not awarded him mark as he was deserving. As a result of which he fell short of 48 mark, as a result of which he became deprived of a consequent selection and appointment. Under the circumstances, the case was filed, notice was issued by the tribunal, and thereafter it remained pending for adjudication before tribunal. When subsequent period after abolition, it came to the Honorable High Court, and in this case, counter is filed. The counter has no merit at all. Nothing is said, and I have sought for re-evaluation of 3 papers: Public Administration Paper 1, Paper 2, and English paper, wherein he was to secure more mark. And all the answer schemes which have been
Why have
annexed.
they not tagged this petition? Let's make a note of it. Why have they not tagged? I'm specifically asking. So what was his age when he filed the application? What is the age limit?
Millard, at the time of age limit, Millard.
2 questions, sir.
Yes, Millard.
What was your age when you filed the writ petition? Question number 1.
Yes.
Question number 2 is, what is the outer age limit for being appointed under the Orissa Civil Service?
Millard, at the time of filing the application, his age was 33. And
when did you file that application?
Millard, in the year 2017, the case was filed before the tribunal.
And your age was 33.
At the time, 33. Result was published in the year 2017. And soon after publication of result, when they found that this is the illegality committed in the process of evaluation.
So you were 33. No, 1 minute. Now answer the second question.
Yes, Millard.
Forgotten the second question.
The present age.
Sorry?
Present, the upper limit. Age limit.
No, your memory is very short, sir. I'm surprised. Lawyers actually are supposed to have very good memory. Okay, second question. What is the maximum age for sitting in an OCS exam?
Operational limit, my lord.
You're getting an assistance of the entire court, sir. It's quite remarkable. They're all able to clearly hear what I'm saying except you.
My lord, in fact,
Your mind is somewhere else.
no, my lord. In fact, I have.
When I
no
argue
exact
before,
idea.
I used to, as a lawyer, when I argue for court, listen very carefully to what judge is asking. I have to answer the judge's question. I can't tell the judge after he has made a question to say, oh, I forgot what question you asked.
My lord, I have no idea about that. Actually, what is the upper age limit? That I have.
Will that have anything to do with the matter becoming infructuous? No.
No, my lord, because
Has it anything to do with the matter becoming infructuous?
no.
No.
Because, my lord, at the time of filing of at the
You
time,
have not even applied your mind. Why do you think the single judge said it is infructuous?
my lord, at the time of making application, he was within the age. He was
Now,
within the
so-
age, and the case remains sub judice before the tribunal and the Honorable High Court.
You answer the question, then you can say all this. You answer the question first. What is the upper age limit for getting appointed under the OCS? You don't know. You have not applied your mind to it. You take your time, sir. Counsel
Your
for the
lordship, I pray for some.
counsel for the appellant wants time to answer the questions of the court.
My lord.
At his request, list on 3rd May.
Item number 12.
My please, your lordship. In this matter, my lord, petitioners challenge the illegal and unauthorized construction of the marketplace on the plot number 172217231728 with the khata number 539. Plot number 72, my lord.
Just come to the cost title, sir.
My
You
lord.
have the cost title page. You have the cost title page.
My lord.
How many opposite parties are there?
Page 3, the retro page.
5.
Which of these people are the encroachers?
Opposite 3, my lord. Collector.
Collector is the encroacher.
No, my lord.
Encroachers are not part.
Let him answer, sir. He might say you're the encroacher, you never know.
No, my not party, my lord.
You have to make them party or not?
Party, my lord.
Counsel to the petitioner seeks leave to withdraw the present petition with liberty to file a proper representation naming all the encroachers, and after following up with such representation, alleged encroachers seek appropriate remedies in accordance with the order.
Item 13.
My lord is directed to file an affidavit. I have placed it on record.
Mm.
Your lordship, 1 week time may be given to file rejoinder, your lordship. I have just received now, your lordship.
What does the counter say?
Paragraph 7, 8, 9, and 10.
Where is that counter?
Not that.
When did you file it?
I just handed over to the court master today.
I just received it.
It's on top, I think.
Yeah.
I'm not.
More on agent. More on
वापस कर Everywhere steps are being taken, There's no commitment to any time limits, sir.
It speaks more about the sanctions they have made, not on the ground.
No, actually, all the work, it's only being saying are being undertaking, or somebody else will do it.
My lords, may kindly look at para 13.
No, let's go step by step, sir.
My lords.
Para 5, end of page 2.
My lords.
Steps are being taken to construct. All right. So we don't know what steps have been taken to construct and what's the timeline. You say that work has been entrusted to superintending engineer Mahanadi South Division, but we don't know what the timeline is. Then come to para 7.
My lords.
Minor repair of pipeline fixtures are being taken up as and when required on emergency basis. And the corporation is deposited with Watco for sinking. So we don't know whether that's happening or not. There's no time limit.
Since Watco has taken up the work, in that gap that is there, the tube wells have been.
Have they been? Then you show me the photographs. Then para 8. The Deputy Commissioner CMC in charge of sanitation has been directed to take immediate steps for cleaning. Due to construction of roads within the rehabilitation site, door-to-door have been hampered. After completion of the construction work, door-to-door collection will be streamlined. So we don't know when will all this happen. Then para 9, paver block road. The work is in progress through in-tender and is scheduled to be completed before monsoon. So I'm just saying there's no timeline for any of this. Even para 10, balance 2 toilet blocks are under construction.
44 have already been constructed.
No. The question is it enough for the kind of population we have there? Shortage of toilets is one major issue, sir. And then para 13, steps are being taken by civil supply officer to tag the rest of the ration card holders.
Work in progress, 100 have already been done.
No, 100 out of how many households? We don't know that. So I'm saying everywhere there is no commitment to any timeline. Even in para 14, peripheral development have been undertaken. Such works are also in progress.
Let me file a short affidavit, my lord.
Say an affidavit dated 4th April 2023 of the Commissioner, Cuttack Municipal Corporation, has been handed over to the court. First of all, although it states that many individual items of work, like provision of a Geri Banda bracket embankment or provision of water supply, sanitation work, provision of toilet blocks, and issuance of ration cards are all and peripheral work and peripheral development work are all in progress or have been entrusted to some agency. There is no commitment to any definite timeline within which these works will be completed. Paragraph. And a supplementary affidavit be filed by the CMC, clearly indicating the timelines within which the works in question will be completed. Said affidavit be filed at least 1 week prior to the next date. List on 16th May.
My lords, deeply obliged.
Item number 14.
May it please your lordship. And at the representation of the petitioners regarding encroachment of village Gochar lands by opposite part number 4 and 5 is pending before OP number 3, my lord. The representation is at
All right.
Page number 18.
Representations, bracket, annexure 2 will be examined by the Tahsildar Delang, and after notice to the petitioners and opposite parties 4 and 5 and giving them a hearing, a reasoned order shall be passed not later than 15 June and be communicated with the parties within a week thereafter. The court clarifies it has not expressed any view.
objection.
Item 15.
May I please, your lord. My lord, prior to that, my lord, the petitioner had approached this honorable court. The lordship will get the order at page 19, annexure 3, my lord. At that time, my lord, on instruction, my lord and friend said that at that time there was no proposal for auctioning the sand soil in question. Now, my lord, on annexure 4, they are proposing to put those 2 sand soil for which, my lord, the earlier writ application was filed. The lords will get at page 21, serial number 5 and 6.
Objections have been invited. So you must have
Objection
filed
I have
objections.
I
Why come to the court so soon?
No,
Let
now,
them
my lord,
consider objections.
let them consider my objection.
When did you file your objections?
My lord, I filed my objection that is on 22nd of March 2023. Page
Alright.
3, my lord, the postal
Alright.
receipt are
It is
there.
only on 22nd March 2023 that petitioners filed their objection to the notice dated 1st March 2023, issued by the Tauzi section of the issued by the collector Baleshwar.
It is to the balance collector.
Since the said objections are still pending, it will be considered in accordance with law by the collector Baleshwar. And a decision thereon be communicated to the petitioners not later than 15th May 2023. If aggrieved by the decision, to be open to the petitioners to seek appropriate remedies in accordance with law.
Item number 16.
16, it has become infructuous, my lord. In fact, I have also no instruction from the client.
No instructions.
Item number 18.
18 what charge employees?
Sorry,
14.9.
14.9. All right.
May give that copy, madam?
Yes, please.
Item number 19.
No, please dismiss.
Item number 20.
20. At page 12 with the input order, my lord. Here, my lord, that the only difference that by that time that man has retired from service, and the Honorable Single Judge has directed in view of that Premlata Panda case that you allow him to continue even after his retirement. That is the only short point. He retired from service on 31/12/2014. So we gave that notification on 7/2/2015 by enhancing the retirement age from 58 to 60.
No, what's the position? We have not considered these appeals or already considered and disposed of.
My lord.
Show us that order.
I'll give you in similar case, your lordship has already dismissed.
That's what.
So I'll give that dismissal order.
All right. In view of the order dated dash in writ appeal dash, the present writ appeal is also dismissed.
In view of Premlata Panda's implementation, your lordship have dismissed.
That's what.
Item 21.
Mr. Behera was mentioning that regarding outsourcing.
8th August.
Item 22.
22 are 49, similar to item
49.
18.
All right.
Item 23.
Item 23, my lord, as there is 267 days delay in filing the writ appeal, I have filed my objection. But in a batch of matters, my lord, your lordship, as it was a fast day disposal, the lordship has been pleased to pass the orders. This is during the long pendency of the vigilance case. Promotion has been granted by the Land and Single Judge, my lord.
The same order?
My lord. But delay was 267 days, my
All
lord.
COVID, sir. No question. Delays conduct. All right. Same order.
Item 24.
My lord, this 24, this is the DO, the regulation, Tahsil, but first day disposal.
Lordship, I am permitted to file a written note of submission.
All right. Orders reserved. Written note be filed within 3 days. 3 days you file it.
No.
Lordship, within a week.
3 days.
Within a week.
There are enough written submissions already.
Item number 25.
Who are applied for the post of Chowkidar cum sweeper, my lord. The guideline is at page 11, annex 2, my lord. At page 12, the guideline provides preference shall be given to local candidates. If the candidates are not available in that locality, then block will taken as an unit, my lord. This part was skipped by Honorable Single Judge, my lord. In the order, lordship turn to page 28, the Honorable Single Judge order, my lord. At paragraph 5, the grievance of the petition is that totally misplaced, since such kind of stipulation has not been mentioned against the post of sweeper in the said guidelines. But guidelines stipulated local candidates shall provided. This part of the guideline was skipped by Honorable Single Judge.
Sorry?
My lord, the guideline stipulates, my lord. You'll also turn to page 11, my lord. The guideline, my lord.
Yes.
Clause 2 is the advertising provided for the Chowkidar cum sweeper, my lord. Clause 2, my lord.
Yes.
Then you'll also turn to the next page, my lord. Page 12. Top, my lord. Preference shall be given to local candidates. This condition, my lord, was skipped by Honorable Single Judge while deciding the case at the dismissal at the stage of admission, my lord. That is mentioned in page 29, paragraph 5 of the order, my lord. Saying that the grievance of the petition is totally misplaced, since such kind of stipulation has not been mentioned in the post against the post of sweeper in the said guidelines, as well as in the notification under the next one. But it was there in the guideline, my lord.
No, it's only for quick cook, sir. Just come to page 11 and 12.
Yes, my lord. 11, my lord.
You're applying for Chowkidar cum sweeper.
Chowkidar cum sweeper, my lord.
There are only 3 bullet points.
3 bullet points, my lord. Then you'll also turn to the next page, my lord.
That is for cook, sir. The cook thing starts at 3.
Yes, my lord.
So all these bullet points are for the cook.
My lord, this is for common, my lord, for all, my lord.
How do we know that?
This is paragraph 12, the preference, my lord.
No, see, the bullet points are coming one below the other. See, 1, then there are 4 bullet points. 2, there are 3 bullet points. 3, there are again.
these 2 point paragraph 12, my lord, it is common for all, my lord.
How do we know that, sir? You have the original advertisement.
It is common for all.
How do we know that? What is your position? Is it common to all? These two conditions. He says it is common to all categories.
I'll have to take instruction on that.
All right. The stipulation, single quotes, preference shall be given to local candidates, unquote, mentioned in the guidelines issued by the Odisha Adarsha Vidyalaya Sangathan. Is, according to counsel for the appellant, a general stipulation applicable for all the posts advertised and not just for the post of single quotes cook. So in other words, according to the appellants, the above stipulation applies even to the post of single quotes chowkidar cum sweeper, unquote. Counsel for the state prays for some time to seek instructions on the above aspect. That is request list on 15th May.
Item number 26.
26. My lord, item 26, 27 and 28. Same as, my lord, yesterday, the WA 789 of 22, it's moved to 13.7. Similar.
Right. Item 29.
29 my lord, outsourcing, 8th August.
8th August.
Item 30.
30 similar to item 28. Adjourned to 13th July.
13th July.
Item 31.
31 my lordship, 13th April.
13th April. All right.
I am giving the term.
Item 32.
None appears dismissed.
Item 33.
30th my lordship, 14th September.
14th September.
Item number 34.
Please, your lordship. My lord, the Metron was disengaged by a summary order, your lordship, without following the procedure. Though it was a contract. My lord, as per Group C, Group D, Post Contractual Appointment Rules 2013. Rule 96. My lord, conduct and discipline, CCA rules is applicable. I have given the rules I have given, my lord. 9(6) of that rules, your lordship.
These rules have been repealed now, no?
Repealed in 2021, your lordship. But I was appointed in 2015-16, your lordship.
Yes.
So, my lord, without any opportunity being given to me on the basis of simple so cause, I have been disengaged on the allegation that a child dies, my lord. I gave my explanation that 22 such children, they suffered. I took all medical attendance except for the ill luck, my lord, this child died. So cause was issued, I filed a reply and I was summarily dismissed it. And disengaged, my lord.
No, but you've not completed 6 years of contractual service.
No.
So how will you get applicability of 10? Rule 10.
Rule 10, your lordship.
Unless you complete 6 years, you're not entitled to.
My lord, on the date of satisfaction completion of no, that is not it is. Regular appointment. That is regarding regular appointment. She shall be deemed
No. This requirement of holding an inquiry, where do you get that from?
This rule covers, my lord, that.
Which rule?
6. 9(6).
Conduct and discipline.
Yes, your lordship. Rule 9, sub rule 6. And in fact, your lordship, there is a judgment to this effect also by Honorable Single Judge. Mr. Manoj Kuntia is our lawyer there.
All right. Perhaps Nasangi learned senior counsel, the petitioner submits that even though the appellant may have been a contractual employee, the Odisha Group C and Group D posts bracket contractual appointment bracket rule 2015 applied to the appellant. So in particular, to submit that under rule 9(6) of the Orissa Group C and Group D post contractual appointment rules 2013. Those the contractual employees were to abide by the Odisha Civil Services Conduct Rules 1959 and would be subject to the OCS bracket CCA bracket rules 1962. So in other words, it is submitted that without prior notice to the appellant, she could not have simply been removed from service without an inquiry. Say notice, Mr. Kunti accepts notice for opposite parties, respondents 1, 2, and 3. Notice will now issue to the opposite party, respondent before by registered speed post, tracking report with place and record.
I can receive notice for respondent 4 also. I can receive notice for respondent 4 also.
4 also, all right, to all the 4. List down. July 5th.
Item 35.
Madam, kindly see page 32. It's a faster disposal, but my lord, why I am taking my lord to page 32? The direction is to file a fresh representation. My problem is, my lord, that latter part observation shall consider and dispose of the same was appropriate, taking into consideration the ratio decided in Umadime, ML Keshri and Amarakanti Rai. So, my lord, if my lord will allow me to take that decision independently, then
No, in light of in taking into consideration, so nothing. If you think it does not apply, you say it does not apply in your order.
That with that clarification, my lord.
No. There's no need, sir. There's nothing. The impugn order simply requires the appellant to consider the representation of the respondents in accordance with law. Such a direction does not call for interference. The period of the paragraph, however, the period of 2 months granted by the learned single judge will begin to run from today. The appeal is dismissed with the above instructions.
36 same.
Same 36.
Item 37.
37, my lord, is rehabilitation appointment. 38. 30th August.
30th August.
Item 38.
38 is, my lord, outsourced regulation. That is 8th August.
8th August.
Item 39.
39 I have challenged. The matter relates to a recruitment matter. The Honorable Single Judge has said, by a flux of time, the matter has become infructuous.
Counsel for the appellant states that the matter has become infructuous due to passage of time.
My lord.
No. What is your submission? That it's become infructuous or it is not?
No, my lord. I have a case, my lord.
Yes.
My lord, can impugn order 37. I have challenged the order of the Honorable Single Judge since I have a case.
What was your case? What is it about?
The petitioner has applied for the post of Assistant Executive Engineer, under ST category. He did well in the written examination and he has secured much more. But in the viva test, he only 1 mark despite answered questions as per the viva board, my lord. But he did not award only 1 mark. I have, my lord, kindly see on that ground, though some less meritorious candidates have got appointment, my case has not been considered. On that ground, I have filed case and the counter has not yet been filed in the writ petition, my lord.
Counsel for the appellant states that the writ petition which was disposed of by the learned single judge by the impugned order dated 17 August 2022 on the ground that it had become infructuous, was in fact not infructuous. Full stop. The subject matter of the writ petition was the non-selection of the appellant. As assistant executive engineer bracket civil. Whereas many of the less meritorious candidates have been appointed. So he submits that the writ petition had not been rendered infructuous and could not have been disposed of on that basis. He also states that the counsel who made that statement on behalf of the appellant did not have instructions to do so. Should I say that?
Yes, well, I have taken that. Yeah.
You say notice. He accepts notice for the respondents.
For 2 mile. For opposite part 2.
All right. Notice will now go to OP number 1, respondent number 1, where it's been posted to the tracking public placed on record by the next date. July 31st.
Item 41, 46 also same prayer.
All right. 41 and 46.
But different exam, my lord, only different.
All right. We've seen the exam 41, 46.
Item 40.
8th August outsourcing.
Outsourcing 8th August.
42.
42, my lord. Promotion I have given the order, my lord. That is 11th May actually. I was right. Item 4. Same order.
Same order. There was one more matter.
Item 4.
Item 4. Got it.
Item 43.
None of this.
Item 44.
May I please? This matter has become infructuous since the appellant has retired in the meantime. So I pray.
All right. Memo files. Take the record. Disposed of as infructuous.
Item 45.
45, I pray one pass over on behalf of Mr. Kanunga requested for pass over.
All right.
Item 47.
47, ma'am. May I take my lord to the very advertisement, page 51. My lord, may kindly have page 51.
Yes.
My lord will find clause 5, eligibility B, capital B. My lord will see educational qualification.
Yes.
We have 3 categories, my lord. One is
yes.
My lord, 3 categories. One is TGT arts. Then my lord will find at page 52 TGT science and TGT science CBZ. TGT science is again subdivided to 2 categories, PCM and CBZ. Now, my lord, I will take my lord to page 51. TGT arts, below TGT arts, my lord will find provided that in any case, the candidate must have passed the bachelor degree if any two school subjects offered as pass, honors, elective, optional, compulsory subject out of the following: English, Odia, Hindi, Sanskrit, history, geography, economics, political science. These are the subjects now. Now, my lord, not disputed, advertisement is not challenged. This stipulation is not under challenge. Now, these four cases are there. Now, these candidates who applied, they said that they, in the while submitting the forms, they said that they have the subjects. We accepted. During verification, we found that they don't have these subjects as stipulated in the advertisement. Now, what they said, my lord? They said we have, my lord, for example, my lord, may come to page 52.
Yes.
My lord sees English, Odia, Hindi, Sanskrit, history, geography, economics. Now, they say we have business economics, which is nothing but economics. And
I may interrupt, my lord. This similar matter is 53 last occasion, my lord's heard, and particularly directed me to submit that examination mark sheet of +2 regarding school subject. Whether the school subject stipulated, so far the graduation for the trained graduate teacher is concerned, whether school is HSC or in +2. To that effect, I have also submitted appeal, that is 53. Let it be hard first. I think it will be better.
He has just served a copy. Your lordship may call this matter next week so that I can take instruction on this.
All right. So we'll take it with 54.
52, 53, 54.
I mean 54.
All matters are same.
Same.
So your lordship can decide.
Challenging the judgment of the honorable single judge.
47.
When is it coming up?
Miller.
Oh, they're all today on board.
Exactly.
yes.
Today it is in the board, Miller. In item number 54.
So you're filing that additional affidavit?
Yes, Miller.
Just
My lord, last occasion, my lord's director. And have a glance to the order dated 16/3/2023.
Yes.
My lord, has specifically directed. My lord, the crux of the point is, so far this judgment of the honorable single judge, my lord, it is available in page 238, my lord, of the writ appeal.
Item 53.
54, my lord.
54.
1296 of 2022 writ appeal preferred by the government.
One triple four, right?
1296. Possibility this sub item.
That's a second sub item.
Exactly. I'm sorry.
Yes. Page.
The pertinent page is 238 of the
yes.
judgment of the honorable single
19.
judge, my lord. They are in at page 19, my lord. May I read it, my lord?
Para 19.
Yes, ma'am. It is apparently evident to any reasonable man from the averments placed and submissions advanced that the subject of communicative English and English implicate the same subject. Additionally, the subject economics takes under its purview the subject of macroeconomics and microeconomics, and thus business economics is the same as the subject of economics. Therefore, the action of the opposite party in not allowing the petitioner, despite of possessing all requisite and essential qualifications, and after qualifying the computer-based test CBT to be appointed as a trained graduate teachers, is erroneous and arbitrary. Then, my lord, page para 20. Accordingly, while allowing both the aforesaid writ applications, this court set aside the rejection order of the candidatures of the petitioners in the selection process and direct the opposite parties to consider the candidature of the petitioner in the light of the fact that they possess all requisite qualifications and have qualified in the CBT. Both the writ applications.
So therefore, my lord, the honorable single judge has essentially.
No, let's see what
I'm
let's read this additional affidavit.
Then, my lord, I will invite my lord's kind attention for a moment. Page 55. This is the advertisement. I'm in subclause B, my lord, where it has written educational qualification.
Yes.
the minimum academic and professional qualification, bachelor degree in arts, commerce, or a Shastri in Sanskrit, degree from a recognized university with 2 school subject, bracket, school subject as defined in the proviso hereunder from a recognized university having 50% of mark. Then my lord, skip to the last part. In any case, the candidate must have passed the bachelor degree with any 2 school subjects offered as pass, honors, elective, optional, compulsory subject out of the following. Then my lord, English, Odia, Hindi, Sanskrit, history, geography, economics, political science, Indian economy, landmark, Indian history, Indian geography, and Indian polity. My lord. So in economics, my lord, in commerce stream, my lord, in commerce stream, the person those who are completed +2, they are in the economics known as business economics, and the English is communicative English. And that has been clarified by the Utkal University about the similarities. And also in my additional affidavit I have submitted, can have a glance to. My lord, in page 9 of my affidavit, my lord, for a moment. My humble submission is the 2 school subject, it is up to 10th, my lord. So that should be economics, as they are saying in their advertisement. This is, my lord, social science. It consists of SSG and SSH. The total marks is 100, my lord. For better clarification, I have filed this B2, the syllabus. It is at page 14 of this affidavit. The social science having 2 sections. My lord, got it? Page 14. The social science, Samajik Vigyan, it is of 2 sections, my lord. One is history and civics.
Civics and geography.
Exactly. Then second one is geography and economics. This is in school subject matter. So for the history and civics is concerned, it is 35 and 15 is total 50 marks. Then so far the geography and economics is concerned, 35, 15 marks is total. Total 100 marks in social science matter. That subject I have in my matriculation. And so far this English is concerned, in our state in HSC, the first language is Odia, second language is English, and so we are taking it as English. And so far this school subject is concerned, this is, and that I have procured in the Right to Information Act from the Utkal University, which is at page 16. I filed it in C1. The relevant page is page 17. With reference to the later subject cited above, I am to inform you that the business economics and the communicative English is equivalent to BA Economics, BA of Utkal University as per the equivalent committee held on 22/3/2022. The next page is the decision of the equivalence committee. And that apart, the similar persons, in this writ appeal and the writ, 3 persons are there. I am 1 million. So other 2 persons also, they have got appointment. I have given that appointment letter.
Oh, I see.
For that, they cannot also pursue. And the other person, similarly situated person in different district, they have got the benefit. Only 2 to 3 districts, this problem arises because of the communication gap. They are understanding that economics, it is not macro, micro and business economics. In that way, they are interpreting, which has been rightly taken care of by my learned single judge, my lord, in the judgment.
My lord, about other district court, my friend is saying yes, no document.
My lord, I have given in the kind of a glance to page 20.
Today you are giving.
Exactly. I have today.
I have to take instruction on this.
My lord, that is their documents, my lord.
If you are giving it today, how do I know it? Just now in court. But as my friend has put it, my lord has heard it. Equivalent.
Yes.
Yes, my lord. But question is there such a thing in the advertisement itself? You are not challenging the advertisement. My lord knows. Just 4 days back, the judgment has come.
Not required. No. It's not business economics. He now says in social sciences,
My lord.
it's economics itself. It's not business economics.
No,
That is the school subject as they are interpreting.
Item number, my lord is taking up now in item 54.
1296.
My lord. Item 54, this petitioner has, he claims to be same in economics and English. Now, my lord, what he has, he has communicative English?
No.
Yes, my lord.
No. He has SSH and SCH.
No, my lord, that is in the schools he's showing. Advertisement says 2 school subjects in your graduation. 2 school subjects in your graduation.
Oh.
That he doesn't have. Now, yes, my lord, I understand. What, my lord, I fully, on this honorable court, honorable single judge, I can't say it's wrong, my lord, that yes, because the equivalent, but the dictum is very clear of this, the honorable Supreme Court. You can't read into it. Equivalent, you cannot declare equivalent. Even if such a equivalence is there, my lord, I concede such a equivalence is there, but it's not there in the advertisement. If it is not there in the advertisement, how can you take that relief?
Where is the degree certificate?
My lord?
Where is the degree certificate? You have to file your degree certificate. Right?
Degree he doesn't have.
I have a degree certificate in page 13. Ma'am.
13?
Okay, exactly. It starts from 12. Utkal University degree of Bachelor of Commerce. And then given the mark list.
No. What is this abbreviation for?
Application for
abbreviation.
trained graduate teachers.
No, sir. Subject. What is the subject abbreviation?
Subject, my lord, they should have the English and economics.
Sir, come to page 13. This is your mark sheet.
Yes, ma'am.
Which subjects satisfy this requirement?
Satisfies page 9, my lord. Page 9
Sir,
of my school
this is
subject.
your graduation, college graduation, BA.
Graduation certificate is at page
13, sir.
Page 13.
Which subjects? You show us the subjects in this page 13.
My lord, it is compulsory English, my lord.
No, COM English. It's communicative English, sir.
Communicative English.
Not English.
Communicative English.
And then the economics, which is the other one.
The other one is the economics, my lord.
Where is that?
There it is in graduation, it is business economics in
BE.
commerce stream.
No, BE.
Again. BE.
There's no explanation of these abbreviations anywhere.
Business economics, BE.
There is no examination. I mean, there's no explanation. There's no legend saying BE means business economics.
No, they have not given in the marks.
That is business economics.
That is business economics.
So that equal. So unless the advertisement says or equivalent there too, his point is that usually advertisements say either these subjects or the equivalent there too.
Yes.
That is not there in the advertisement.
Well, so far the advertisement is concerned, can have a glance to the advertisement at page 55. In any case, the candidate must have passed the bachelor degree with any 2 school subject offered as pass, honors, elective, optional, compulsory subjects.
Right.
They are in English. My lord, so far the English is concerned.
You haven't communicative English.
My lord, in commerce stream, there are 3 streams, art, science and commerce. In commerce stream, in the higher secondary, it is known as communicative English. And so far this economics is concerned, so far the art stream is concerned, that is known as business economics. And that is the syllabus.
That is as far as +2 is concerned.
+2 and +3, my lord. They are in become and ICOM. So far the commerce stream is concerned, it is known as a, for that purpose, they have also clarified in the subsequent in 2023 and 24, they have added this business economics and communicative English.
Where is that?
That also I have filed. Can have a glance to page. Page 43 for a moment.
Today's affidavit.
Yes. It starts from page 36, F by 1. This is recruitment of teachers in government secondary schools.
Oh, they now said subject to result of this.
Exactly. They have added it. Knowing very well that they have. So economics, macro, micro and business economics, the syllabus is same.
This is really
everywhere. And that
you have mentioned this very writ appeal.
Exactly.
So which means you are aware.
That score, the students are suffering, and out of them, others have got the benefit, and they have solved.
No. This is your own advertisement, sir. This is your own document.
But this is subsequent, man. This is subsequent.
Obviously, because you were aware that this is creating difficulties.
Exactly.
Which is why now you have said it includes communicative English and business economics.
Yes.
So there's no, you yourself have admitted this, sir. Now there's a clear admission that it is equivalent now. Clear admission.
Because this was there, because subject to outcome, there is an interim order.
No, these two subjects are in which writ appeals? Yours.
Yes, ma'am.
All these
subject economics and communicative English.
All these writ appeals are for that.
And out of them, others have got the benefit. So far, my writ application is concerned. Let me clarify, my lord. So far, this kind of a glance to page 28, my lord. Other two persons in respondent number 2 and 3. Name is Prabhat Gui and Priti Smita Behra. They have also got the service by virtue of the order dated 18/6/2022 in Odisha Adarsha Vidyalaya Sangathan. My serial number is at page 29, is serial number 24 and 29. They have also got the benefit and served in the Noida district.
Which two, sir?
Page 29.
Serial number?
Serial number is 24, my lord.
Priti Smita.
This is Priti Smita. She is respondent number 2, my lord. In this writ appeal and in writ application also, petition number 3.
And then
kind of a glance to page 20, the serial number 29.
Prabhat Wayne.
Yes, exactly. I am in petition number 2 and respondent number 3 in the writ appeal.
All right. No, they also had only communicative English and business.
Communicative and this economics. They have been served and they have got appointment and they have joined.
I see.
In Nagar district. 2-3 districts apart from that, in all other districts they have accepted these persons having the same qualification which has been clarified.
All right.
In item 54, in the first item, my lord, it relates to chemistry, TGT CBJ.
You're not appearing in that.
Not in the second case.
No. First case. Item 54, first case,
that
it relates to TGT CBJ. So there the subjects are life science, where they claim equivalent status.
Milord, I have produced one clarification issued by the IGNO, who speaks of the fact that the life science is consisting of two subjects, that is zoology and botany. And I have, at the time of making application, I have stated that my two subjects are one chemistry and another zoology. And life science, which I have read in the degree level in IGNO, that the IGNO has made it clear that life science is consisting of two papers, zoology and botany. So in that view, that aspect has been taken care of, has been considered by the Law Court, by the single judge, and said that he is quite eligible. And moreover, my application was submitted, that was scrutinized. And thereafter, I was allowed to clear the CBT computer-based test. I cleared that. And thereafter, when merit list was published, my name was notified in the ineligible list. And thereafter, I got a cause of action to challenge that. And they said that your life science is not cannot be compared with zoology. That is clarified by the IGNO, wherein I have read, I have got the certificate.
So that aspect has been taken care of and considered by the honorable single judge. And this person who,
Let's see, what do they say for this life sciences? Mhm. No, yours is TGT science.
yes, this is science, CBZ.
Yes, again, subject to 1,444. Everywhere you've done this. Life science now you've clarified. Everywhere you've put writ appeal number, sir. Okay, 1,444 also is taken care of. Then, which are the other? 1,321. In 1,321, what is the question, sir? In 1,321.
1,444 by 22,
That is over, sir. Now we are on this other, where we started, 1,321. What is the subject in item 47?
Item 47, subject, first subject is this communicative English and business.
So same thing. All right.
First. Then 53, same.
So wherever it's business and communicative English, all right.
Ma'am. 54, second item, which Mr. Mohanty was doing is communicative English, business economics. Only the 54 first item.
It's
That
life
is-
sciences.
Madam, that is chemistry and
Life science, all right.
47, I am there, my lord, but my name is not appearing. So for the read is concerned, I am there.
You've already appeared for the for this Vijay Ketan.
Exactly.
All right. So put down this 1,321. Then 1,444, 1,296, and just the fourth one.
1,431, item 53.
And 1,431. All right. All these appeals arise out of a common.
And 50 to 53 also same.
Oh,
That is
52 also. All right.
Yes, that is commerce.
All these appeals arise out of a common judgment dated 6th May 2022, passed by the learned single judge in the corresponding writ petitions, whereby the non-consideration of the candidature of the corresponding respondents for for admission to for appointment as trained graduate teachers (TGT) in the stream of arts or science was held to be illegal, and a positive direction was issued by the learned single judge. To the present appellants to consider their candidature open quotation in light of the fact that they possess all requisite qualifications and have qualified in the CBT, unquote. Paragraph. The background facts are that an advertisement was published by the School and Mass Education Department, Government of Orissa. On 28th August 2021 for different posts of TGT in the government secondary schools. Full stop. The notification indicated the eligibility norms. Stop. Relevant to the present cases is the educational qualifications that were to be possessed by the candidates. Full stop. As far as the post of TGT bracket arts is concerned, the requirement was a bachelor degree in arts from a recognized university, open quotation, with 2 school subjects, bracket, school subjects is defined in the proviso hereunder, bracket, from a recognized university, having 50% marks in aggregate, bracket, 45% for SC/ST/PWT/SC/BC candidates, bracket close, and bachelor education, bracket B.Ed, /3-year integrated B.Ed-MEd from a NCTE recognized institution, unquote. Paragraph. The proviso read as under, open quotation. In any case, the candidate must have possessed the bachelor degree with any 2 school subjects offered as pass/honors/ elective/ optional/ compulsory subject out of the following: colon, English, Odia, Hindi, Sanskrit, history, geography, economics, political science, Indian economy, landmarks in Indian history, Indian geography, Indian polity. This take from page 56 of Writ Appeal 1296 of 2022. Paragraph. Barring Writ Appeal 1444 of 2022, in the remaining writ appeals, the controversy was around the candidates having graduate degrees in single quotes communicative English, unquote, and single quotes business economics, unquote. Which, according to the appellant, did not strictly conform to the requirement that they should have graduated in plain single quotes English and plain single quotes economics. Paragraph. The learned single judge has, after noticing the across the state, the course of English is called single quotes communicative English in the BCom degree, and economics is called business economics in the BCom degree, denying BCom graduates the opportunity to get appointed as TGTs. On the above ground would be to use a open quotation hyper-technical approach, which is wholly arbitrary, which amounts to an artificial discrimination, which cannot hold in law, full stop, unquote. The learned single judge understood communicative and English to mean the same subject. Just like economics would include macroeconomics, microeconomics, and likewise business economics. Full stop. The learned single judge also took note on the fact that each of the respondent candidates had also passed the computer-based test bracket CBT and were therefore otherwise eligible to be appointed as TGTs. Paragraph. In Writ Appeal 1444 of 2022, the controversy was whether the respondent candidate had satisfied the norm stipulated the educational, satisfied the educational qualification for the purposes of being appointed as TGT bracket science. That is, possessing a bachelor's degree
CBZ.
CBZ, right? TGT science bracket CBZ category bracket, where the candidate should have possessed a bachelor's degree in two of the school subjects, that is open quotation, chemistry, botany, zoology, biology, and biotechnology, unquote. The candidate here possessed a bachelor's degree in single quotes life sciences, unquote. And according to the appellant, this could not be treated as equivalent to single quotes botany and zoology, unquote. Here, the learned single judge accepted the plea of the respondent that in the Indira Gandhi National Open University, bracket imbue, life science course was considered equivalent with botany and zoology, bracket biology. And that the imbue authorities had supplied such information under the RTI Act. Paragraph. It is submitted by Mr. Mishra, learned counsel appearing for the appellant in these appeals, that inasmuch as the advertisement itself did not recognize any single quotes equivalence, unquote, with the above subjects, the learned single judge could not have simply treated communicative, single quotes, communicative English as the same as single quotes English, or business economics as single quotes economics, or zoology and botany as, or single quotes life sciences, unquote, as zoology or botany. Full stop. This, according to, was reading into the advertisement a stipulation that did not exist, and therefore the impugned order ought to be set aside with this court. Paragraph. In one of the writ appeals, that is Writ Appeal 1296 of 2022, counsel appearing for the respondents, candidates, has filed an additional affidavit placing on record the subsequent advertisements issued by the appellants for recruitment of TGTs in various streams, including arts and science bracket CBZ. Full stop. In this fresh advertisement, both single quotes business economics and single quotes communicative English have been added with an asterisk mark, stating that candidates possessing bachelor's degree in such subjects, open quotation, are provisionally allowed to participate in the recruitment process, unquote, subject to the result of WA number 1296 of 2022 pending in this court. So likewise, against the post of TGT bracket CBZ, it has been clarified that candidates possessing a degree in single course life science, will be allowed to participate, subject to the result of WA number 1444 of 2022. Paragraph. What this indicates to the court is that the appellants have themselves recognized that the equivalence between single courts communicative English, and English, business economics and economics, and zoology and botany with single courts life sciences, and are prepared to accept candidates possessing graduate degrees in those subjects as being eligible to participate in the recruitment process for the posts of TGT bracket arts and TGT bracket CBZ bracket. It is then argued by Mr. Mishra that the subsequent advertisement can only apply prospectively. Full stop. The court notes that this change brought about in the advertisement was precisely on account of the impugned order of the learned single judge, which, although challenged in this court, has been accepted for future advertisements. Stop denying the benefit to candidates who have in fact succeeded before the learned single judge would be really subjecting them to an unfair discrimination when the same benefit is allowed to candidates candidates applying in subsequent advertisements. Stop. The court sees no prejudice being caused to the appellant in extending the benefit of the judgment of the learned single judge to those very candidates who have succeeded before the learned single judge. Paragraph. For the aforementioned reasons, the court does not consider it is not satisfied that grounds have been made out for interference with the impugned order of the learned single judge. Full stop. The appeals are accordingly dismissed, but in the circumstances, no arrest was.
Item 47 is included. Same.
Yeah, we've included. 37, no?
47.
47, yeah. 47 we included.
That has been included.
Yes.
Item number 48.
48 minutes, my Lord friend, Mr. Kuntia is appealing for caveator. I am serving copy on it. So the fact of the case is that the appellant and the respondent for they both are applicant for the Gola Bogoda Anganwadi Center. According to the advertisement,
you not removed the defects, is it? There are many defects, sir. You remove them.
My lord.
List on 3rd May defects be removed in the meanwhile. Yes.
Item number 49.
May I please, Your Lordship? Well, the appellant has challenged the order of the learned single judge, my lord, where the learned single judge has rejected the IA of the petitioner, my lord, on the ground of that there was no application for condonation of delay, my lord. Lordship, kindly have a glance at page 187, my lord. The impugned order which is under challenge, my lord. Page 187, my lord. The matter is taken up through hybrid mode. Had learned counsel for the petitioner. This is an application for recalling of order dated 17/12/2015. Since the IA has been filed much after the period of limitation and no application for condonation of delay has been filed, this court is not inclined to entertain the IA. The IA is accordingly rejected, my lord. Here, my lord, under Annexure 9, my lord, I have filed a IA, my lord, stating all the grounds why the delay took place, my lord. That was not considered, my lord.
What's the ground?
Lordship, client have a glance at Annexure 9, my lord. Annexure 9, page 169, my lord. Well, the advertisement was issued in the year 2014, my lord, to fill up the post of secondary teachers, my lord. My lord, this case, my lord, the petitioner approached this honorable tribunal challenging the advertisement, my lord.
Come to para 3, sir. That's the only reason for the delay. Come to para 3.
Yes, my lord. That the present petitioners have no knowledge about the said order 17/12/2015 passed in OA number such and such by the Odisha Administrative Tribunal, Cuttack, as the counsel conducting the aforesaid case, namely Prakash Chandra Mahanti, has already left practice. Besides that, recently on 8/9/2021, when the petitioners contacted the advocate Mr. Prakash Chandra Mahanti, told about disposal of the aforesaid case being wrongly tagged to another batch of cases.
No, but what happened between 17/12/2015 and 8/9/21?
My lord, they were not aware of the case.
What happened, sir?
My lord.
Not being aware is one way.
Yes, my lord.
They never followed up.
Yes, my lord. They did not.
They should follow up with their advocate, sir.
But interim order was there, my lord. But this case was wrongly tagged with another case, my lord.
All that is fine, sir. We are only on the gap, the time gap.
Well, time gap, my lord. Lordship may sympathetically consider, my lord.
No.
Well, as interim order was there, my lord.
Right.
And similarly situated person, they have already got a judgment of this Honorable High Court in 2022. And that order has already been implemented, my lord.
That's all.
Lordship may sympathetically consider, for no fault of the petitioner, they should not suffer, my lord.
No. Recall orders, you've given sample recall orders, no? 11/8/22 is one recall order.
Yes, my lord.
In some other matter.
Yes, my lord.
In your matter, the fact remains is it was dismissed in 2015 itself.
Because, well, it was wrongly tagged with another matter, my lord.
No. The delay, sir. We're not on what.
Yes, my lord. Yes, my lord. I'm conscious of the delay, my lord.
Delay has to be some satisfactory explanation of the delay, sir. This is no explanation.
But the advocate who was conducting that case, my lord.
No. You can't wait for 6 years. You have to keep following up with your advocate.
And my lord, that corona period also.
All that is only started in 2020, sir.
I only pray, my
you
lord.
You just slept over after 2015 for 5 years. You slept.
But as vacancies are there, my lord.
No. Doesn't mean that suddenly. What seems to have happened is when others started getting relief, you woke up suddenly. You never followed up. Okay.
Well, they are from a remote district, my lord. They are not aware, my lord.
No.
A fault of the advocate, the petitioner should not suffer, my lord.
No. Up to a point, all that is acceptable, sir. Not otherwise.
Only, my lord, sympathetical consideration of the case, my lord.
No. You see, the challenge is the present petition is to an order dated 11th August 2022, passed by the learned single judge, dismissing IA number 1005 of 2021 filed by the present appellants, seeking recall of an order dated 17/12/2015, whereby their petition civil OAC number 2003 of 2015 was dismissed. Where is that order?
My lord.
That dismissal order, 2015 order.
Well, 2015 order, that is Annexure 8, my lord.
Right.
Yes. Page 65, my lord.
Was dismissed by the Orissa Administrative Tribunal. Along with an entire batch of cases. Paragraph. The learned single judge has observed that the IA had been filed long after the limitation period without any application for continuation of delay. Paragraph. Counsel for the appellant refer to the IA number 1005/2021 which is an application for recall, and submitted that the reason for the delay was indicated in the said application itself in para 3, although no separate application for continuation of delay was filed. Paragraph, this court has perused the said para 3, which basically states that the lawyer conducting the case on behalf of the appellants did not inform them of the order passed on 17/12/2015 by the OAT, and that only when they contacted him on 8 September 2021 that he informed them of the setback by stating that their case had been, single quotes, wrongly tagged to another batch of cases, unquote. Paragraph, the above paragraph 3 of the application still does not explain what the appellants were doing between 17/10/2015 and 8/9/2021. Full stop. Even, as suggested, even if, as suggested by counsel of the appellants, the COVID period had to be accounted for, the COVID-19 period had to be accounted for, still the gap between 17/12/2015 and the onset of the COVID-19 pandemic, that is in March 2020, is still not satisfactorily explained. Stop. Although a litigant should not suffer on account of the lapse of his lawyer, here it is seen that the litigant did not bother to contact his lawyer to know of the status of the case for more than 5 years, and that is clearly inexcusable. Full stop. The sum total is that the court is not satisfied that any satisfactory explanation is, any reasonable explanation has been offered for the inordinate delay in filing the application for recall of the order dated 17/12/2015 passed by the OAT. Paragraph, it must be noticed here that after the abolition of the OAT, it is all the cases, including the disposed of files of the OAT, were transferred to the High Court. And therefore, an application in a disposed of OAT matter would also only be taken up in the High Court. Paragraph, the court finds no good reason to interfere with the impugned order of the non-single judge. The writ appeal is accordingly dismissed.
Item number 50.
50, my lord, works at 14th September.
All right, 14th September.
Item 51.
51, my lord, outsourcing 8th August.
8th August.
Item number 55.
The petitioner, before the lordships in the writ appeal, challenging the order of the Honorable Single Judge, my lord, whereby the Honorable Single Judge has dismissed the application by not accepting the petition, the delay in filing the notice for issuance of notice to the opposite parties.
That's right. Notice is issued in 2011. You filed requisites in 2022. What is this?
My lord, that's the difficulty, my lord. Inadvertently, it was not filed.
Oh.
When the petitioner inquired, when the advocate inquired into the matter for not being listed, and came to know that the notice was not filed, so he filed immediately.
Not immediate. 11 years later, you can't count. You said there is the impugned order reveals that there was an 11-year delay in filing requisites without any explanation, without any reasonable explanation being offered for such an inordinate delay in taking the very basic steps to pursuing the writ petition. Consequently, the court is not persuaded to interfere with the impugned order of the non-single judge. The writ appeal is dismissed.
Item 56.
56, my lord, the ICDS supervisor, he has prayed for regularization. The Honorable Court had directed to cover up that with the Patita Pavanda.
So in view of the judgment dated so and so and so and so, the writ appeal is dismissed. All right. That you have still give us the details. You've given it?
Sorry.
You've given us the detail of that.
Yes, I will give. This matter is not covered by that. This is separate. Lordship to issue notice in this case and similar matters are fixed to 16th July.
16th July.
Right.
Notice return is 16th July.
Item 57.
In 57, my lord, we pray for 1 week time to remove the defects.
All right, list on 3rd May, defects be removed in the middle.
From 58.
Yes, sir. 58, 60 and 70. These three matters you are also already fixed 24th July.
24th July, all right.
May copy may be served on behalf of yes, that's
Obliged. Item 59. Sir.
At 59 parcel, one parcel.
Passover.
My lord.
All right.
59 seconds.
Item 61.
May I please, Your Lordship? Your Lordship, in the present writ appeal, the order passed by the single bench has been challenged. Your Lordship, in the present petition, the petitioner was a government headmistress and she retired in the year 2006. However, even after producing all the documents, she was not given the gratuity and other retired benefits immediately.
So you've already filed a contempt petition. So the single judge is permitted to pursue that.
Your Lordship, it was filed before the Odisha Administrative Tribunal, which has already been abolished.
But it's been transferred here. Even the contempt petitions have been transferred here.
Your Lordship, however, the petitioner was left with no remedy. That's why the petitioner
The
filed
contempt petitions have been transferred here. You have to just follow up where the contempt petition lies now. It must have been transferred here and been renumbered. Have you found out what has happened to the CPC1S of 2018?
No, Your Lordship. That
So you
has
find
not
out
been done.
that. You go to the branch here, they'll tell you. At the request of counsel, the appellant list on 12th May 2020. 16th May 2023 to enable the counsel for the appellant to ascertain the renumbered contempt petition CP bracket C number 1 bracket S of 2018, which was pending in the OAT. All right.
Item number 62.
Obliged.
Item 62, my lord, departmental proceeding, vigilance case. Lordship has fixed to 11th May. My lord, the contempt has been filed. The matter was so stay of that order, my lord.
All right. Till the next day, there shall be stay of the same order.
I may pardon, my lord. Item 59 is similar to that 54. That your lordship just disposed of the matter.
Patita Pavan Padda.
Yes, commerce that
in view of the judgment. All right.
Today's item number 54.
Not today's item. No, today's 54 is different.
Today's item 54.
Today's your lordship dismissed our read.
Correct.
That is
so today's 54 is similar to that.
59.
59. All right. Mahantis. So this is also art stream.
Commerce.
Your
lordship similar material.
Correct. TGT arts. All right.
Item 63.
63, Malona, kindly come to page 21. It's the order of the Honorable Single Judge starts from page 20. My lord, the eligibility, my lord, has already seen this advertisement in other cases. 45% for SC, ST and OBC, my lord. Now, this candidate had 44.32. That has been, my lord, rounded up to be made eligible. My humble submission, my lord, that is not permissible.
Correct. The impugned order directs a rounding off of 44. What is his mark, sir?
50, that is 40, my lord, I have stated that in (44.32). My lord, may kindly see
Rounding off of 44.32 marks as 45%, which is the minimum eligibility requirement for appointment to the post of TGT.
TGT.
Sorry?
TGT Arts.
TGT Arts. You see, there are sufficient decisions of the Supreme Court of India that do not permit such rounding off. Notice returnable. 17th May. There shall be stay of the impugned order till then.
Obliged.
Item 64.
Hello, the state is not a party in this appeal. This is regarding a dispute regarding allotment of a shop room in a market complex of CDA. What has happened, my lords? Your lordship may kindly have a glance at paragraph 1 of the appeal memo, only paragraph 1 at page 4.
Yes.
The sole petitioner was a handicapped, unmarried person. He filed the petition, writ petition before the Honorable Court, praying for allotment of that land. There is a rival claim. Opposite party number 4 is the person who was challenging or opposing the prayer. And during pendency of the writ petition, he died. So his mother...
application was filed.
Immediately, IA was filed, the IA number 8178 of 2022. Pending disposal of that IA, without passing any order in the IA, the Honorable Court dismissed the writ petition filed by the petitioner on the ground that the CDA has already made some other arrangements. Although, admittedly, there was a status quo order passed by the Honorable Court in this said writ petition from the date of filing of that application. And in the meantime, after there is, your lordship, there is a very less delay of only 3 months. The mother is before your lordship, the son has died, and the mother has filed the substitution application, and she is also a widow. And this, in the meantime, it is learned that the CDA has issued a letter after the death of the petitioner. They have issued a letter allotting the land to the opposite party, being hand in gloves with this opposite party number 4. I have also prayed for an order of status quo to stay the operation of that letter, 13th September 2022. And I have not been heard. This is the order passed against a dead person without any substitution. This is a fit case to remand the matter to the Honorable Single Judge for hearing.
Whom are you for?
I am for the petitioner. No, he is with me. He is Animes Mahanti.
He is my associate. It is pointed out by Mr. D.K. Mahanti, learned counsel for the appellant, that although the petitioner had expired during the pendency of writ petition civil 14046 of 2020, and a substitution application to bring on record his legal representatives was already filed, was numbered as IA number 8178.
My lord, IA number
8178.
8178 of
2022, and was pending before the learned single judge, the impugned order does not notice the above fact and proceeds to dismiss the writ petition, noting that the shop in question, which was applied for, has been allotted already in favor of opposite
Respond
party.
number 4.
Respond number 4. Full stop. It is pointed out that this very same allotment is challenged.
In respect of that allotment, status quo order was there during pendency of the writ petition.
In respect of that allotment, the status quo order
from the very beginning
had already been passed right from the beginning. Paragraph. Notice returnable 16th May. The status quo as was prevailing during the pendency of the writ petition will continue till the next day.
My lord, may I pray that delay may be condoned? There is very less delay. 3 months.
How much days delay?
3 months.
3 months and
20 days.
So notice on that.
Notice.
Notice on both delay.
Yes.
All right.
the status quo which was prevailing
Yeah,
during the
that's what
pendency
I
of the
said.
writ
Yeah.
petition.
Item 65.
My lord, 65, 66, rehabilitation appointment, 38. I will take notice. Written number
38.
38.
Got it. Oh, 30,
67.
308, correct.
67, 68 also rehabilitation.
68 also, all right.
67, 68.
Oh, 67, 68 also, all right.
Item 69.
There is a delay of 4 days. I will file the condemnation
All right,
delay
all right.
petition within 2 days, my lord.
All right, tell us.
I could not able to file the delay petition and condemnation of delay.
Tell us what the matter is about, sir.
My lord, matter relating to, this is a matter where the, my lord, your lordship kindly see the order passed by the honorable single judge, Annexure 3, page 46. It is an relevant page is 48, my lord. This is a case filed against the order passed by the Revenue Divisional Commissioner under section 15B of the Odisha Survey and Settlement Act. There, the petitioner has purchased the land since long. He could not mutate the land in his favor. After publication of the ROR, he has approached the authority, who is the Revenue Divisional Commissioner for Mayurbhanj District, and under the section 15B of the Odisha Survey and Settlement Act, my lord. And that has been rejected by the order. It's page 40, my lord, the relevant.
So there is no claim against anybody. You were just asking for mutation.
No, my lord, no claim against anybody else. It has been
So why should
recorded.
he go to the civil court, Mr. Mohanty?
My lord, it is not the civil
My
court.
lord, this type of cases your lordship has already dealt with. The honorable single bench in many cases directed that this revisional order is no way affecting your right title interest, and you
But
can
he has a sale deed in his favor.
sell it in his favor. There must have been some rival claim. That is why
There is no rival claim. That's why I asked him. There is no rival claim. There's no other party. There's no contesting party at all. He's simply asking for a mutation.
No, it is not mutation. Correction of record of right. In
okay.
exercise of power under section 15B. Because 15B, there are so many things the commissioner has written. Not
Correct.
simple
It's only
mutation
correction.
that.
Okay. Even if it's correction, I mean, it's an ineffective mutation. But anyway, if it's correction of record of rights, then there's no rival claimant. There should be no problem. What does the revisional order say?
Yes,
My revisional order, your lordship, page 40.
Page
440.
40.
Page 40. Relevant page 40. Page 39, it's at Annexure 5, my lord. There they have stated that I could not able to file the documents relating to plot index, other things, my lord. Those I have filed, I have given the index, my lord, which I have filed the document before the revisional court. Everything I have filed, my lord. Only I pray that may be perished and order may be passed by the revisional court.
No. The observation is that he failed to establish the flow of title. The flow of title he failed to establish.
But that
which is a matter needs to be examined by the civil court.
No, my lord.
Whether he has.
Then 15B is a defunct one.
No,
because I have purchased the land, that is the procedure to file the revision petition, my lord. If you will go in each and.
No, 1 minute. Just come to this page 41.
41, my lord.
Last but one paragraph.
You read that whole paragraph. It is a fact that Sabik
It is a fact that Sabik plot number 115, Sabik plot, Khata number 159931 was recorded in favor of Chintamani Patnaik, my lord. Jodumani Patnaik, son of Damodar Patnaik, but the flow of right title interest from Sabik RT to claimant is not well justified, as petitioner could not explain how the vendor Parasamani Patnaik got the power of attorney from the son. It is not correct, man. From the son, not the son. Your lordship may see, I have the Odia annexure.
Next one. Further, the land schedule is also not confirmed from the state deed.
Man, that is land schedule I have submitted before the court. That is also confirmed. My lord,
Where
if
is
your
all that,
lordship
sir?
give, I will give to throw an affidavit, the document which I have filed. Some documents in the writ petition is there. I have given it with it. In the plot index I have filed before the court below. I can file here also through way of affidavit.
These
my
are
lord.
the factual findings, your lordship. The commissioner has referred the documents and came to a conclusion that
And
the
this type
original
of orders has been passed, though the documents have been filed. Several orders has been, I can draw your lordship's attention, several orders has been filed, passed by the commissioner. Thereafter, that has been recalled, my lord, after filing of the recall petition.
I pray commissioner may peruse my documents and give an opportunity.
Unless you know whether we have established this chain.
Yes, my lord. Your lordship may see, my learned brother can go through the Yadast Amin report, which has been submitted during the time of settlement operation. There, that has been categorically stated, my vendor has a right, it should be recorded in the name of my vendor.
Saying is one thing, producing documents to show the flow of right.
Your lordship may give, only I pray, I may be given a liberty to file within 7 days. I can file before the court will afresh. Those documents afresh. The originals are with me, my lord. The certified copies.
Yes, he can file a petition to recall this order.
Yes, ma'am.
And satisfying the infirmities which the commissioner has observed.
Yeah, it is seen that the Revenue Divisional Commissioner. No, secretary. It's a court of secretary.
Yes, Revenue Divisional Commissioner is the authority, my lord. For Mayurbhanj district.
Oh, RDC is
RDC, Revenue Divisional Commissioner, Central Division, my lord. Page 39.
Why does it say in the court of secretary?
My lord, that for the for an interim arrangement, because there are at that time a Revenue Divisional Commissioner is not sitting for an interim arrangement. Secretary, who is an IS officer, he has been allotted with this case. Now the Revenue Divisional Commissioner, Central Division, is taking the matter.
All right. It is stated that the Revenue Divisional Commissioner, bracket Central Division, Cuttack, before whom the appellant's application under section 15 bracket small b of the Orissa Survey and Settlement Act 1958 bracket OSS Act bracket had been filed. Dismissed the revision petition number 74 of 2018. Seeking a direction to the Tahsildar Baripada for correcting the record of rights, bracket ROR, of the suit land in the favor of the petitioner on the basis of a registered sale deed by which the petitioner became its owner, the appellant became its owner, and also took possession. Full stop. It is pointed out that the impugned order dated 25th November 2021, which was challenged before the learned single judge in petition civil 80 of 2023. Has rejected the appellant's prayer only on the ground that, open quotation, the flow of right, title, and interest from Sabik RT to the claimants is not well justified, as the petitioner could not explain how the vendor, Parasmani Patnaik, got the power of attorney from the son of the Sabak RT. Unquote. It is further observed that, open quotation, the land schedule is also not confirmed from the sale deed. Unquote. Consequently, the appellant submits that the appellant has in his possession sufficient documents to not only establish the flow of right, title, and interest, but also to show that the land schedule mentioned in the sale deed is consistent with the prayer made for correction of the ROR. Paragraph. Counsel for the state submits that if the appellant does possess such documents, then he should file a review petition before the RDC. Is that review permissible?
No. Recall petition.
Recall petition before the RDC under section?
There is no section for that.
If there is apparent error in
Error on the
face of the
face of the
records,
record, they can
and he
recall
can
it.
establish that there is error, then court can recall and pass a fresh order.
Okay, a recall application before the RDC. Paragraph. In view of the above submissions, while setting aside the impugn order of the single judge, as well as of the learned single judge, this court permits the appellant to approach the RDC with a recall, with an application for recall of the order dated 20 November 2021, passed in RP number 74 of 2018. So if such application is filed not later than 1st May 2023, then it will be considered in accordance with law by the RDC, and after hearing the appellant, the reasoned order shall be passed thereon within a period of 2 months thereafter. No further directions are called for at this stage. Writ appeal is dismissed.
Oblige. Item number 71.
Seventy-one, 14th
14 September. All right.
Item 72.
72 also 14th September.
All right.
Item number 73.
Sattapada 8
May.
Item 74.
14th September.
14 September.
Item 75.
75 is my lord, similar with 39, but here is a different. That matter is related to appointment. This matter is related to promotion. The honorable single judge has directed.
Anyway, no counter file, nothing.
In this case, no counter file.
All right.
Only difference, this matter is related to promotion, my lord.
Right. It is seen that the impugn order of the learned single judge was passed on the very first day without noticing that readings were not completed in OA number 3893 bracket C of 2012, even before the Orissa Administrative Tribunal, which application was transferred to the High Court and registered as petition civil OAC number 3893 of 2012. On the ground, it's become infructuous.
The honorable single disposed the matter become infructuous. Though the petition, the appellant is eligible to get promotion after exonerated in the DP and also
But why is it said infructuous? This is not similar to the other matter then.
Kindly see, Lord. The honorable single is directed and can see the order, man. Which is under challenge, man. 76, my lord. The writ petition has become infirm. My submission is that the appellant is eligible to get promotion to the rank of ASI of police on the ground that in the vigilance case he was acquitted and the departmental proceeding has dropped, my lord.
So only pension you will get.
Only pension.
But otherwise you were dismissed from service, is it?
My lord.
What was the original order? You were challenging the OA.
I have challenged in the OA to consider my case for promotion to the rank of ASI police from the date when my juniors have got promotion and other financial and consequential benefits.
All right. Say, counsel for the appellant, take off the whole thing. Counsel for the appellant submits that the prayer before the learned single judge was for a direction to the opposite parties to give the appellant notional promotion from the day that his juniors were promoted, so that his pensionary benefits could be reworked correspondingly. So he accordingly submits that the matter had not become infructuous, as was wrongly noted by the learned single judge. Paragraph. Having heard the counsel of the parties, the court finds that indeed the prayer in the application before the Orissa's Administrative Tribunal, which was transferred to the High Court and registered as WPC bracket OAC number 3893 of 2012, was for the aforementioned relief, and merely because the appellant had superannuated, such relief could not be rendered infructuous. Further, it is seen that no counter affidavit was filed by the appellant state even before the OAT. For the aforementioned reasons, the impugned order is set aside. The matter will now be listed. The WPC OAC number 3893 of 2012 will be listed before the roster bench of the learned single judge on 21st August. The respondent state will file its paravis reply to the writ petition on or before 7th August, and the appellant herein will file its rejoinder thereto on or before 21st August. No further time will be granted to either party for that purpose. Not 21st, 17th August. The not 17th, which is that 14th August. What did I say? 21st August. The court clarifies it has not expressed any view on the merits of the matter. The learned single judge is requested to proceed with the writ petition on merits and endeavor to dispose it off as expeditiously as possible. All right.
Item 76.
76. My lord, 76 is vouchers regulation, that is 14.9.
14.9.
Item 77.
May I please, Your Lordship? The impugned order starts at page 16. The operative portion at page 28. Honorable single judge has relied upon its order, earlier order passed in OA number 726 of 2017. The only distinction is that there are two separate rules governing two separate cadres. Here, the promotional channel is different from the another promotional channel in another cadre. So they have equated both the cadres.
What happened in this writ petition civil 5544 of 2022?
Well, that I'm saying that is not in respect of the same cadre. See the cadre, I have annexed that rule, my lord.
Which cadre is this and which is that other cadre?
This is the cadre, my lord, VAW to overseer. Then the another cadre is, my lord, that is the rule, my Odisha Agriculture and Food Production Service Method of Recruitment and Conditions of Service Rules 2012. As for this rule, the base level post is Assistant Agriculture Officer, then District Agriculture Officer, then Deputy Director onwards, my lord. But Honorable Single Judge had directed to grant the benefit accrued in the cadre of Assistant Agriculture Officer. Our case before Honorable Single Judge, they are initially appointed as VAW. Next promotion is Agriculture Overseer. Since there is no other promotional avenue thereafter, they are entitled to the grade pay of 4,800, not 5,400. And we have, after the order of the Honorable Apex Court, we have issued a notification. The Lordship can find it from Annexure C by 2, page 64.
No, but they are saying that they are similar to petitioners in OA 726.
That our case, Your Lordship must see page 64. That we have issued the notification of all the cases. What has been dealt with, the principal case is that Biharlal Bari case. In that after Biharlal, the case that has confirmed before the Honorable Apex Court, we have issued this guideline. And on the basis of this guideline, and Your Lordship can find it from page 63, that we have fixed a grade pay that is 4,800 where there is no promotional avenue.
It says notice returnable. 28 June.
Item 78.
I'll stay up input.
But item 78, I am in.
One minute, sir. 77?
Stay up input.
Is there a in contempt?
They have not filed because a batch of cases.
It's all right. Just
No, what
notice
has,
of that.
what has happened in this case, contempt has had batch of cases, my lord. So contempt has been filed in other cases. We have that's
All right. Till the next date, there'll be stay of impute order. All right. Yes, sir. 78. Yes.
78, Madam, because I'm suffering from cold, I'm in VC, Madam.
No problem.
So actually, this is a matter where actually the institution filed an application for declaring that the trust is a trust estate. If your lordship looks annexure 1 to the writ application, under 13D of the OEA Act, which has been subsequently repealed, that provision, they have been declared as trust estate. But section 224E, C and D and E specifically provides if it's a trust estate, the provision with regard to sealing, which subsequently incorporated in the Whaler Act, will not be applicable as per section 38. But if you will mark here, but the properties are being donated to the mahant of an institution in his individual capacity, though it is used for the temple itself or the matha. But that has been held in 67 Supreme Court and also 2019 Supreme Court, the Justice Gopal Godavala. But that Puri matter. Here, actually, we wanted to file an application that sealing proceeding is not maintainable so far as the properties are concerned, because we had also made an application to exempt it, to declare it as a privileged royat and a trust estate under section 57(1) of the 57A of the Whaler Act. But the authority said, once you have already declared the trust estate, the subsequent application 57A is not maintainable. And they refused. That is Annexure 4 order in the writ application. But the Honorable Single Judge held, as if Malad is a personal property of the Mahant and therefore it will come under the sealing proceeding. But the Mahant cannot have a personal property in a matter. But your Lordship knows that Amrutavanai decision also itself shows that is all property of the institution. It cannot be segregated. No individual can utilize it. Even a lot of matters of the Mahants, they have been included in the Puri temple also, administration Puri temple. Now, this is one of such property which we want should be declared in favor of the institution. That is what the Honorable Single Judge said, that since it has not been declared under section 57, therefore it will not be. But 13D has already been declared of the OE Act. That declares if it is a trust estate under section 38, is a privileged royat and it will be exempted from sealing. That order is a subject matter of challenge for Lordship. That is the legal proposition and crux to the matter.
You say notice, we don't need the member board of revenue to be a party.
No, not member board of revenue.
You say by the oral request of Mr. Mishra and senior counsel to the appellant, respondent 4 is deleted from the array of parties. Then you say the consolidated costs have to be filed within a week. Then you say notice, he accepts notice on behalf of 1, 2, and 3.
And endowment commissioner, Ms. Naidu, is to be noticed.
Endowment commissioner has to be made a party, no?
Yes, I'll make him a party. Endowment commissioner was present actually when Single Judge disposed of the matter, and they have also granted me the permission to file.
In the first part, you say at the oral request of Mr. Mishra, the Commissioner of Endowments Odisha is included as respondent before, and then you say consolidated cost.
Well,
notice is accepted on behalf of the respondents. List for hearing on. What is this IA for?
So IA is
delay is there. Delay is there.
Delay
is all right. Delay is
Commissioner granted me permission to file. Continuation of delay. The other is stay.
No, stay I strongly oppose because this is a vast piece of land where the
sir, it's a public.
This is the admission stage. We have to file counter or we have to see the records. Your Lordship may see this is a vast piece of land, around 500 acres, involved in the airport. Puri airport is going to be established there.
And we are claiming our individual property.
No, that you are saying about the merit of the case. That can be decided at the time of the hearing. But at this preliminary stage, I pray your Lordship not to pass any interim order. If IA is there for interim, your Lordship may issue notice. I will file counter.
All right. Notice on IA. All right.
Only thing your Lordship may indicate, but I am not praying for stay, my lord. now they cannot distribute it to the other beneficiaries. They
So
can,
that is equal to stay. How we will distribute because it is airport authority will take. That is your lordship may not record it, my statement, but this is the fact. My lordship knows it. Everybody know it that it is the airport is going to be established there, and the after much.
I don't know. I don't know. At least I don't know.
You know. You know it.
On this plot, airport is going to be established. I don't know.
Anyway, lordship may issue notice in IA also.
All right, notice in the IA.
Item 79.
My lord, date is fixed to.
Sorry. 12 July.
Item 79, may I please? This matter may be taken up tomorrow.
All right.
A copy of the writ appeal be
Yes,
served.
yes, I'll serve.
All right.
Item number 80.
My lord, affidavit is now produced to me.
I have solved the affidavit right
All
now.
right. What does he say?
It is a matter relating to moral policing. And the Honorable Court directed the government to file an affidavit regarding departmental action.
Where is that? Where is that affidavit? I have not got it. What does the affidavit say? You have a copy?
Yes.
We don't have a copy.
The originals are here. We have filed it in intermediate.
My lord, any other date may be fixed so that I can.
All right. A copy of the affidavit will be brought in, filed by the state, we brought in record. Petitioner who appears in person needs time to examine it and make submissions. 21st June.
Obliged. Obliged.
After lunch. Right.
Number 81.
My Lord, 81. I am appearing on behalf of Mr. B.P. Tripathi and kindly seen order number 10. Affidavit of Chief Secretary not served upon me.
Not served. It is already served on Mr. Tripathi. When the receipt is there, I will again serve it. On 16th February, this affidavit was served on Mr. B.P. Tripathi and Mr. B.P. Das.
We are only dealing with one river here, is it? I thought this PIL is not just about one river. No?
I am appearing for opposite party number 6, Pollution Control Board. I have already filed affidavit.
This is only river Damsala. Damsala is a tributary of Baramani.
Brahman, yes.
All right. You say an affidavit has been filed on 3rd April 2023 by the State Pollution Control Board, stating that it has been monitoring the water quality of Brahmani River and its tributaries
On
at
a monthly
41
basis.
stations, as compared to 26 stations in 2000 now, as compared to 26 stations in 2014. Stop. 37 out of the 41 stations, the water quality conforms to the quality of a class C river. It is claimed that the conformity percentage has increased from 3.8 in 2014 to 90.2 in 2022. Two sewage treatment plants, one in Talcher and one in Rourkela, have been established, taking the total septage treatment plants. No, apart from 15 septage treatment plants, and one more is stated to be under construction. Stop. It is further claimed that it has been ensured, open quotation, that all major industries in Anagul district adopt functional zero effluent discharge system. Stop. Unquote. It is further stated that Mahanadi Coalfields Limited in Talcher has also adopted functional zero waste water discharge system. Unquote. The chromite mines are stated to have upgraded their effluent treatment plants. For treatment of hexavalent chromium. And have installed online monitoring systems regarding discharge of wastewater to the Damsala Nala. The results of monitoring for the period January to December 2022 have been enclosed. Full stop. It is assured that SPCB is keeping a strict vigil on the Brahmani river water quality. And will continue to take necessary remedial and coercive measures. Against any party causing a downgrade in the water quality. Paragraph. Counsel appearing for the CPCB states that he has still not received a copy of the affidavit of the Chief Secretary. Mr. Mohakari takes to serve him a copy to date, sir. The affidavit of the CPCB will be filed by the next date. List on 17th May. 17th May.
Item 82.
Lord, item 82, my lord. My lord, 1 week time for file affidavit. Due to illness, Mr. Rao is not present, so.
Affidavit was to be filed within 2 weeks from December, sir. Not now. It had to be filed within 2 weeks from December.
Lordship, just two last.
Do you have the paper book? Where is your paper book? Have you got the order? Turn to the order dated 7th September.
My lord, one document required, so not filed. Lordship, last chance, lordship.
It was adjourned in September, adjourned in December.
Tomorrow, lordship.
No.
Tomorrow, lordship. Listen.
How will you file an affidavit by 1 day? You will file the affidavit. You will file an affidavit in 1 day.
Yes, lordship. As per my senior instruction, lordship.
I'll record your submission. You better be serious. I'll impose very heavy costs if you make a statement now and don't file the affidavit. You better be certain now. Don't make casual submissions before a high court. You'll file the affidavit by tomorrow?
Yes, lordship. As per my lord's senior instruction.
If you don't, we are going to dictate in the order. You'll pay heavy costs.
1 week time, lordship.
Don't keep shifting like this. This is not some magistrate's court.
Sorry.
Have some seriousness. You are addressing a high court.
Sorry. Sorry.
I don't know why they send people without any instructions just to go and seek time. Your senior has sent you just to go and take time. That's it. Nothing else. I think we'll close this PIL. Enough of this. What are your instructions? Who's for this?
Our last occasion on 7th September, that order shows that we have said that there is no land. He has stated there are some lands. He will give the details so that I can take instruction.
All right. You say despite opportunities granted on 7th September and again on 7th December, no affidavit is forthcoming from the side of the petitioner who claimed that there is land available for the purposes of upgrading the school at Keshara beyond 8th class. Stop. The court does not propose to grant any further indulgence to the petitioner on this score. Paragraph. As and when the petitioner is able to give details of the land that is available, he will place those details before the Secretary, School and Mass Education Department, who will then take an appropriate decision thereon in accordance with law. No further directions are called for. The petition is disposed of.
Item number 83.
Lords, on the last occasion, my lords directed to make a video photography of the entire road, the stretch. Lords, I have made it, but unfortunately that pen drive got corrupted, my lords. My lords, 2 weeks time may kindly given to so that I can.
My lord, my pen drive is still available with you, my lords. Your lords have verified the presence of all. That
No, my lords, the opposite party is only showing half side of the cake, which is fully baked. That's it.
Stage 1 to stage end, my lord. That is
No. That is only the stretch that the half side of the cake which is baked, and the unbaked side they are not showing. My lords, 2 weeks time may be given. I will give the
Mr.
entire
Samal
photograph.
says that the pen drive which carried the video that he had prepared to show the current status of the stretch of the highway in question got corrupted, and therefore he seeks some more time for that purpose. Give me that. You go to the opening, sir. 21st June, opening day, 21st June.
My lords, 4th of May. Please, my lords, the matter will become infructuous then, my lords.
Road will become infructuous.
No, my lord.
This is remarkable, sir.
My lord,
Construction of a road can't become infructuous.
One month.
You may need to prepare 3 more videos and you come with a very strong case. 21st June, monsoon would have started. That's the best time to test your roads. Whatever they have completed also, you can test it properly once monsoon starts.
Okay, man.
21st June.
Item number 84.
In this, I am submitting an objection to the delay condonation petition.
Has filed an objection to the.
What's the delay? How much delay?
Delay, according to them, they have said that 77 days.
77 days. 77.
So from their standards, this is nothing, sir. Their minimum standard is 300 days.
And this is only the stereotype, always that official process, administrative reasons for taking all these things.
We'll say, despite vehement opposition by you, we're condoning the delay. Let's get to the merits.
My lord, Lordship may admit this appeal any other date for hearing. Delay may be condoned any other day. There are 2 appeals.
Today's small victory.
There are so many cases.
09 of 2015. There is a delay of.
Lordship may admit it.
There is a delay of 77 days in filing this appeal. A counter affidavit has been filed stating that by the respondent contesting the arguments in the application. Paragraph. Delay is nevertheless condoned, subject to the state paying the opposite party through counsel a sum of rupees 3,500.
The 2 cases are there.
In each of the
We
cases.
will pay 3,500.
In each of the cases. Within 2 weeks, the applications are disposed of. Then you say in the main writ appeal at the request of Mr. Monty, Learned AGA. List for final hearing. On 2nd August.
No, can be in July, any date.
6th July.
Obliged.
Item number 85.
My 85, 86 and 87. Let's fix it to 25th April.
Okay. 25th April.
Item number 88.
May I please?
Minutes, item 88 minutes. Today minutes, I'm appearing for on opposite part number 5 minutes. Filing booklet. May I pre-minutes may primers to some other day so that I can go through and I can be able to assist.
All right. Mr. Mahapatra appears for respondent number 5 and he sprays for some time to address arguments. Interim order to continue.
Interim order to continue. The difficulty here is, my lord, a trust now, my lord, is facing a public charitable trust is facing this difficulty. And cognizing this, your lordship, my lord, kindly see the order number 3, my lord.
He permitted you to take some money.
No, my lord, has appointed an my lord, receiver. Proposal to appoint. Thereafter, the parties say that we will conciliate. Now there is no chance of conciliation, my lord. Is my lord senior rule.
That is there.
So taking cognizance of the suffering of the students who are prosecuting their studies in the institution run by the trust, my lord has directed this. Now,
Now, what's the exact requirement that you have? You tell us. What is the contingency? What kind of orders do you need?
My lord, I will pray let my lord some sort of arrangement is made so that the
you come up with some suggestion. Then we can consider it. File an application suggesting what can happen in the interim. File an application. All right. That is request list on.
Sorted. I only pray, my lord.
We'll have it
this
on
side, my lord, this side of the vacation.
Yes, yes. We'll have it on 1st May.
Oh, bless.
All right.
Item number 89.
My lord, the order passed by this honorable court on 14th of December 2022 may kindly be seen. Paragraph 5. After this paragraph 5, my lord was pleased to pass an interim order. As an interim order, the applicant, if already relieved, shall be reinstated and permitted to be discharged duty, etc. Thereafter, my lord, this was listed twice before my lord. That is on 14th of February and 6th of March, where the Reliance State Council took time to comply the order passed by this honorable court. Now, my lord,
in this case,
one IA has been filed for modification or recalling the order dated 14/12/2022. Your lordship can have a look to pay running page 10 of that IA. Though it is recently served on me, I have not filed any reply, but I would like to rely on their own IA, my lord. Running page 10, last paragraph. Whereas reinstating the appellant Sri Ranjan Kumar Jit in unreserved category of adjusting against the available shall contravene the provisions of ORB Acts, etc. At present, there is only one vacancy meant for women unreserved candidate is available in the division. This is their own admission. My lords can have a look to the government circular in this regard.
And will dilute, will dilute the future outcome, meaning what? What is diluting the outcome?
Sorry, my lord. Your lordship, paragraph, why we are not able to implement that order? Your lordship, paragraph 9 of my I. Admittedly, there are 2 posts, my lord. 2 vacancies are there available. One for UR women and another for ST, my lord.
He's not an ST, he's UR.
No, he to be only adjusted against UR post, my lord.
Correct.
So since that post is for UR women, my lord.
If there's some other woman, then I can understand. If there's no woman, then what's the problem?
Women, when that in a recruitment, that our notification in a recruitment.
My lord, 47, page 47 can be said. This is the GI department notification issued in as late as in the 1994, clause 3, my lord. Page 47 of their IA. If in any year, the vacancy reserved for a particular category of women candidate specified under sub-rule 1 remain unfilled due to non-availability of suitable women candidates belonging to the respective category, the unfilled vacancy shall be filled up by the suitable male candidates of that same category.
Let me
if
clarify.
that women candidate is available, I can be adjusted.
Let me clarify. My learned senior said that if woman can is not able, here this is a case, my lord, that this is the related to recruitment of the previous years. Here, my lord, the question of not availability or available does not arise. When a recruitment test is conducted, if at that point of time a woman is not available, then that post can be filled up by male candidate.
No, but this case relates to that very recruitment year.
No,
that's what he's fighting for all these years.
Yes. What has happened? In this case, my lord, his appointment has been set aside by my lords.
By the single judge?
Yes, ma'am.
No, by division. Single judge, yes, ma'am. I'm sorry, single judge.
So at that point of that relates to reserve as SCBC.
Okay.
So that his appointment has been set aside.
Now that setting aside has been set aside, sir.
No, not set aside, my lord. What has happened, my lord, that your lordship had an interim order, he can be accommodated. So that our problem that
Virtually that 14 December is like a final order, sir.
yes, ma'am, that's why.
So it's basically to implement that order.
Yes, ma'am, that's why we have filed an IA that is the inconvenience.
And they say there is a vacancy is there in their own affidavit.
Let me complete. I am submitting before. I am not. So that is the inconvenience for which I could not implement. If your lordship will clarify that we can adjust that people against that you are woman, we can accommodate him because our problem we cannot accommodate one against you are woman. And admitted fact he cannot be adjusted against ST post. But this is the position while this writ appeal is pending.
No, suppose we don't modify our order, you'll still have to appoint him against that you are woman only.
Yes, ma'am.
That's the best.
That's because of that. Accordingly, we have filed an IA to that
All right.
effect.
You say,
yes,
considering that IA, you say this court, this is an application filed by the state of Orissa seeking modification of the order dated. No, seeking recall of the order dated 14 December 2022, passed by this court, whereby, as an interim arrangement, the appellant was asked to be reinstated and permitted to discharge his duties as forester by adjustment against an available vacancy in the unreserved category. Paragraph. It is stated that there is only one vacancy in the unreserved category which had been earmarked for a woman. Full stop. Admittedly, there is no woman candidate available for filling up that vacancy. Full stop. Paragraph. In the above circumstances, and considering that it is an interim arrangement, the court sees no reason why it should modify its order dated 14/12/2022. The application is dismissed. All right.
My lords, unless
right. Then the main matter you say, now that IA number 1540 of 2023 has been dismissed, the direction issued in this court's order dated 14/12/2022 will be complied with positively on or before 24th April 2023. List on 3rd May. 3rd May will list it.
3rd May. My lords clarified that again that women candidate vacancy.
My lord has clarified. I have understood that.
I could not hear it because of.
All right.
Item number 90.
May I please, Your Lords?
Yes.
The appellant was initially appointed on 31/7/1992. At the time of appointment, his result was not published and result was published on 23/3/93. The college was established in June 93. Much after publication of the result, and after publication of the result, I have filed application for a regulation of my post, and the governing body regularized me on 25/9/93. After 30 years of my service, and when receiving grant from government, the principal, who is incompetent authority in same cadre, in charge principal, same day joined, he placed the petitioner on appellant under suspension without approval of the governing body. And as per Rule 21 second proviso, the suspension should be made at the initiation of discipline proceeding, and the same should be approved by the competent authority, that is Director Higher Education. I filed a writ petition before the Honorable Single Judge. The Honorable Single Judge directed to file a representation before the President Governing Body, and I have filed a representation which was rejected. Again, I challenged the rejection order before the Honorable Single Judge, and Honorable Single Judge held that this is the res judicata. And in paragraph 6 and 7 of the impugned judgment, even though there was no such pleading by either parties.
How is it res judicata, sir? If a representation is made and rejected, can't be res judicata.
Last 10 months, I am under 11 months under subsistence without any subsistence allowance.
What I humbly submit, man.
We passed an order for that subsistence allowance. What happened to that?
They have not paid, my lord, till late, my lord. Your lordship, on the IA and also writ appeal issued notice, my lord. They have received notice.
Why is suspension allowance not paid?
My lord, suspension allowance, my lord, I assure this honorable court, I undertake, my lord, to be paid. What I was submitting, my lord, he is essentially agreed by the order of suspension, my lord. It's a statutory provision, my lord. What he says is correct. It has to be, there has to be prior concurrence. He can always approve the education tribunal for that.
Education tribunal under which provision?
Section 21.
My division bench order of this honorable court, my lord. Your lordship kindly see.
You're a Reddit college employee. You can go there.
No, education tribunal is not maintainable. I will show the judgment of this honorable court. I have enclosed my division bench order of this honorable court, page 63, Annex 12, my lord. That is Navkishore Mahapatra case.
Page 63.
Page 63.
60.
No, it's not on maintainability, sir. This is not on maintainability.
My lord, that was quashed, my lord. The
No, it
division
was
bench,
quashed, but no question of maintainability was raised here.
neither before the honorable single results, on 2 occasions they have raised.
Oh, did not raise this.
There is no, they're not raised. First time they are saying, my lord, in the opinion.
Then
There
forget
is
it.
no provision, my lord.
You did not raise it before the single judge, you can't raise it now.
Counter filed question. They have filed counter. Yes, 67 counter, my lord.
How long have you been in suspension?
11 months, 10 May 2022, my lord.
So where's the provision which requires a time bound?
My lord.
Which provision? There must be rules or regulations.
My lord, I have quoted, my lord, that is Rule 21, paragraph, page 14, my lord, of the writ petition. Starting from para 18, page 13, my lord. Rule 21(2) of second provision.
Only for a period of 30 days. Only for a period of 30 days.
30 days, my lord. And that should be approved, my lord, by the director within period of 30 days. They have not approved. And division bench in Navkishore Das case, my lord, held that if this is not approved, this should be quashed.
All right. You say the challenge in the present petition is to a judgment dated 27th October 2022, passed by the London Civil Judge, dismissing the appellants. Writ petition civil 16821 of 2022, whereby the appellant had challenged orders dated 10th May 22 and 23rd May 2022, issued by the principal of the Belagunta Science Junior College, as well as an order dated 28 June 2022, issued by the president of the governing body of the said college, placing the appellant under suspension. No, placing the appellant, who was a lecturer in English in the said college, under suspension, pending departmental inquiry. Paragraph. The writ petition before the learned single judge was the second round of litigation. Full stop. Earlier, the petitioner had filed.
Yes, 58.
Yeah. Writ petition civil 13142 of 2022, which was disposed of on 24th May 2022, with liberty to the appellant to file a representation before the president of the governing body for redressal of his grievance and for a time-bound disposal of such representation. That representation by the appellant was rejected on
28, my lord, 28/6.
On 28 June 2022, paragraph. In the impugned order, the learned single judge has construed the above rejection of the above order passed by the learned single judge granting liberty to the appellant to file a representation as precluding the appellant from again filing a writ petition after rejection of the representation. Stop in doing so, the learned single judge has applied the doctrine of res judicata, of constructive res judicata. Full stop. It is stated, it was noted that the appellant was seeking a direction to file a fresh representation before the president of the governing body, open quotation, instead of pressing for quashing of the suspension order, unquote. Paragraph. A perusal of writ petition civil 16821 of 2022, in which the impugned order has been passed by the learned single judge, reveals that there is the very first prayer is for quashing of the suspension orders and not merely for permitting the suspension orders. Full stop. In other words, the prayer was not for making a fresh representation to the president of the governing body. Full stop. Paragraph. The mere fact that a representation made by the appellant against his suspension orders was rejected by the president of the governing body would not constitute single quotes constructive res judicata, so as to preclude the appellant from challenging them afresh in a writ petition once the representation was rejected. Full stop. This is because there was no adjudication in the earlier writ petition on the central issue raised therein, namely validity of the suspension orders. Full stop. Consequently, this court is of the view that the reason for dismissal of the writ petition was unsustainable in law. Paragraph. Instead of remanding the matter to the single judge for disposal of the writ petition on merits, the court considers it appropriate to deal with the merits of the case in the present appeal itself, since the order of suspension is now continued for 11 months. The relevant provision as far as suspension is concerned is
page 14.
Rule 21. The second proviso to Rule 21 bracket 2 of the Odisha Education bracket recruitment and conditions of service of teachers and members of the staff of aided educational institutions bracket Rules 1974, which reads as under, take from top of page 14. Admittedly, in the present case, the managing committee of the college in question or its governing body has not sought the approval of either the inspector or director of higher education, and the after placing the appellant under suspension. Stop. Secondly, the suspension has continued for well over 30 days without such approval. Full stop. It has in fact been in force for the last 11 months. Full stop. Paragraph. In Navakeshwar Mahapatra versus State of Orissa, 1997 2 OLR 470, a division bench of this court held that even a post facto approval by the director of an order of suspension would not satisfy the requirement of the proviso if such approval was not sought within the period of 30 days after initiation of the disciplinary proceedings. Full stop. Further, in Abhimanyu Nayak versus State of Orissa, bracket decision dated 1st August 1983 in OJC number 199 of 1983, bracket, this court held that in terms of the proviso to Rule 21, bracket 2 of the rules, the suspension could not operate beyond 30 days without approval of the director. Full stop. For the aforementioned reasons, the impugned suspension order cannot be sustained in law. Suspension orders that cannot be sustained in law and they are hereby quashed. Paragraph. Dr. Lenka, learned counsel for the appellant, submits that during the 11 months when the appellant was under suspension, he was not paid any subsistence allowance. So Mr. Mishra, appearing for the respondents, assures the court that the subsistence allowance that is due to the appellant will be paid to him not later than 4 weeks from today. The appellant will be allowed to resume duties and appropriate orders in this regard will be passed by the governing body of the college not later than 15th April 2023. The writ appeal is disposed of in the above terms.
Lordship, set aside the input judgment.
Yes, that's been quashed. You see, the impugned order of the single judge is set aside. The writ appeal is allowed in the above terms. No order systems.
Supplemental list passed over matter item number 45.
May I please, Your Lordships? Unless this is a writ appeal against an order of the Honorable Single Judge, whereby the petitioner, which is a cooperative bank, my lords, an award was passed in its favor, and the Honorable Single Judge quashes the award in writ jurisdiction, while, my lords, there is an appeal under the Cooperative Acts, under the 109 is the appellate, is the provision providing appeal.
But he says the award is without jurisdiction.
My lords.
Because the arbitrator was not competent to pass any order.
No, my lords. That is not the finding. I'll just explain the facts and circumstances of the case, my lords. My lords, the loanee he was not a loanee, he was a guarantor. So he had mortgaged his property in favor of the bank, my lords. Now they initiated two proceedings. One is one is under the surface act, and one is before the arbitrator, statutory arbitrator. Now, my lords, what happens? The statutory arbitrator passes his award first, and there, my lords, the plea of limitation and other things were not taken by the guarantor. Anyway, the award was passed in our favor. Now the award remains. Then the surface, my lords, most probably, I don't know what had happened then, most probably they did not follow it up, thinking that already they have won in the before the arbitrator, my lords. The surface authorities, my lords, the DRT dismisses their application on the ground that it is barred by limitation.
Oh. So today there's nothing before DRT. You've gone in appeal to the DRAT.
DRAT, my lords, but they have not preferred an appeal. There is an award in their favor which was passed before the DRT passes its order. The award remains as it is. The award is binding, my lords. That is, the award is, if your lordships...
Award is passed on contest.
Award is passed on contest. Later, my lords, they were noticed, they did not appear. They were noticed, they appeared, thereafter abandoned the proceedings.
Didn't raise the plea of jurisdiction.
No, my lords, no plea of jurisdiction, no plea of limitation. Jurisdiction, this honorable court has settled, my lords, the law that the cooperative banks can proceed under surface as well as file applications under the Cooperatives Act for getting their disputes adjudicated. And, my lords, once this honorable court has also passed, my lords, that a cooperative society, once it gets its award, an award is passed in its favor, it is basically relating to the business of a cooperative society, which is a purely private entity, my lords, and no writ jurisdiction. The writ jurisdiction doesn't lie. So under the circumstances, my lords.
If a notice returnable. May.
Deeply obliged.
Notice on stay also.
I may pardon, my lord. That, your lordship, that matter data entry operator, I am giving that written note of argument. Your lordship has given me 7 days, so I am giving 2 days.
Lordship issues notice.
Yes.
Deeply obliged.
Supplementary stress admission item number 1, CRLMC 304 of 2019.
None appears dismissed.
Item number 2,
None appears dismissed.
item number 3,
Item 3 may please. In that case, my lordship, the case arising out of a matrimonial dispute, my lordship, between the husband and wife, my lordship, and I'm challenging the order of the annexure 4, my lordship, in page 26 to 29, my lordship. In that case, my lordship, the law and JMFC has without application was mine, my lordship, that rejected my lordship, that application, my lordship, that order that he has only on the basis of
You have challenged jurisdiction.
Yes, I am challenging that the present opposite parties are no way residing under the jurisdiction of JMFC Vasudevpur. But
they are your wife and son, sir.
Wife, but they are not residing. As per the lordship, as per the section of the protection for women of domestic PW Act, Violence Act, section 27 says that the court of a judicial magistrate
matter must have proceeded anyway.
But that is written, my lordship. The person agreed permanently or temporarily resides or carries on business or is employed. That it has been the wife is residing, my lordship, in his aunt house, my lordship, which belongs to PS Vasudevpur, my lordship. But he's in opposite party number 2, his son, he is residing in Sora in another jurisdiction, and he is claiming monetary compensation from his husband, my lordship.
All right.
For that reason, my lordship, that
all right. The court finds that by the impugned order dated 2nd February 2019, the JMC Vasudevpur has rejected Miss Case number 67 of 2015 filed by the present petitioner for a direction to the opposite parties to withdraw their case against him on the ground that the said court had no jurisdiction to entertain the petition. Apparently, the objection was on territorial jurisdiction by contending that the minor son of the petitioner resided outside the jurisdiction of the said court and therefore could not maintain a claim for maintenance. Under 125.
Yes, ma'am.
Not PWDV Act. Under the PWDV Act. Paragraph having heard and comes to the parties. Parties. The court is satisfied that the plea taken by the present petitioner was not sustainable because the jurisdiction issue could have been raised at any appropriate stage. No, since as noted by the learned GMFC, jurisdiction could be exercised even where the person invoking the jurisdiction was temporarily residing in the said area. Full stop. As a proposition law, no fault can be found with this. Consequently, the court finds no reason to interfere. Petition is dismissed.
Obliged.
Item number 4.
None appears dismissed.
Item number 5.
Item 5, my lord, on behalf of Jyoti Prakash Tripathi, my lord, present next to you, lordship.
No. What is it for?
My lord.
What is it about, sir?
My lord, he instructed me. I have no power, lordship.
Then I forget it, sir.
My lord.
This court,
Lordship.
you cannot do all this without any
no instruction,
authorization or instruction. An adjournment is simply sought by a proxy counsel appearing on behalf of counsel the petitioner. The request is rejected. Petition is dismissed for non-prosecution.
Item number 6.
None appears dismissed.
Item number 7.
Item 7, liberty may be granted to raise all the
permitting the petition to raise all pleas.
Note 8.
None appears dismissed.
Item number 9.
Lordship, challenging the proceeding under section 107, Lordship. Summons has been issued against me, Lordship, but in summon there is no specific allegation, nothing, Lordship. Lordship, kindly glance at the page.
There's no stay granted here. The proceeding must be over there now.
There is
That
no-
someone was for a particular day, it's all over now. Due to passage of time, the present petition in which no interim order was passed has been rendered infructuous and has been disposed of as such.
Item number 10.
Copy the order be sent to the concerned authority, you see.
May it please your Lordship. Lordship, may I be permitted to place on VC, Lordship?
Yes, yes.
Lordship, the petitioner has filed a CRLMC for quashing of FIR and the entire criminal proceeding relating to GR case number 328 of 2019, Lordship. Raising out of one CC case number 145 of 2019. Lordship, meanwhile, the matter has been compromised and one affidavit has been filed from the side of OP number 2.
All right. The affidavit of OP number 2 stating that the parties have settled their disputes has been placed in record. There is no opposition to the prayer made in the present petition. Consequently, take from the prayer clause and all proceedings consequent thereto are hereby quashed.
Oh, bless the Lord.
My Lord, I am for the OP number 2, my Lord.
All right. This is confirmed by OP number 2, you say.
Oh, bless.
Item 11.
I plead your Lordship. Lordship, here the petitioner is a senior citizen, has prayed for quashing of the criminal proceeding. The offence alleged on section 490 323, 34 IPC and 4 DP Act. And the stand taken by that the case has not been made out on section 490 and other offences. And that on the particular day, the petitioner was not residing with the petitioner.
It raise all these pleas, permitting the petitioner to raise all pleas at the appropriate stage. The petitioner is disposed. Copy the order be sent to the concerned court.
Item number 12.
Item 12, quashing of FIR, my Lord. On the ground of amicable settle the matter, amicable settle between the package, my Lord. And may I pray, your Lordship, permitted to withdraw. In the meantime, the charges are permitted to withdraw with the liberty to file appropriate appeal.
All right. Permitting the petitioner to seek all. Raise all.
Liberty may be granted to file press.
Item 13.
In this case, my Lord, the maintenance has been awarded 10,000. Expertise order has been passed. I could not get an opportunity for a hearing. For that reason, I have filed this case. And
what's the amount awarded?
10,000. But I am getting 5,000 per month. And that has been.
You have complied with this order, not this is 7/3/2015 order.
But about the present position, I have not.
No, it's all right.
I have no.
It's all right. If you have no instructions, you say an order was passed. The challenge the present petition is to an order dated 7/3/2015.
My Lord, till today I have not contact with my client for
Passed
that.
by the learned JMFC, Cuttack, and criminal miss case number 100 of 2014. Whereby the petitioner was asked to pay interim maintenance of rupees 10,000 per month to the opposite party. Why?
In Annexure 5, kindly have a glance 33 page. I am getting 5,000 per month as consolidated.
An order was passed on 30/11/2017, and there has been no stay of the order till date. Clearly, the petitioner should have been complying with the said order, and it has obviously not caused any grave prejudice to him in these years. Considering the cost of living and rising inflation, the court does not consider the amount awarded to be substantial enough to warrant interference. The petition is accordingly dismissed.
Item number 14.
Item 14, no instruction.
No instructions dismissed.
Item number 15.
None appears dismissed.
Item number 16.
May I please, your Lordship? My Lord, here in this case, the petitioner is the accused and he seeks to exhale the order of cognizance under Annexure 3, Miller. And the cognizance, it has been taken in respect of the offences under section 420 and 120B of IPC, Miller. The undisputed relevant facts which has not been disputed by the prosecution case. In the meantime, cognizance has been taken in respect of 2 offences against the single accused, Miller. So far, 120B is concerned, minimum 2 number of accused are, that is the foremost requirement. I will satisfy your Lordship, Miller.
No. What is the other offence?
Miller, other offense 420 and 120B. There is no other offense. Your Lordship may kindly come to Annexure 3, Miller. That is running page 35. That is the impugned order of cognizance. That is consisting of one page, Miller. That is, I am just reading out the relevant sentence, Miller. That is the first part. Received was charge sheet number such and such dated 6/9/18 under section 420 120B IPC against the accused person Ratnakar Pradhan, late son of late Janaki Pradhan, and connected papers 48/6 from the IOSI RL Behera Airfield PS along with prayer for keeping such and such under section 173(8) of CRPC. Peruse the FIR CS case diary 161 CRPC, arrest memo, injury report, seizure list. There is no allegation of any assault or anything. Injury report and seizure, purely non-application of mind, Your Lordship may kindly appreciate. Jimanama and other connected papers from available on record. This court is satisfied that prima facie the offence is made out. That should be 420 and 120B of IPC is well made out. That is the impugned portion of the cognizance order. Your Lordship may kindly appreciate the undisputed fact who is involved in the case. FIR, it has been filed by one Niranjan Lenka. It was filed on 23rd December 2017, Miller. 2017. And that Niranjan Lenka is claiming to be the father of the so-called victim. And the dispute is related to a piece of land, Miller, which is situated under the Khorda Jatni Tahsil, Miller. Allegation is that, Miller, originally that land belonged to one Damodar Behra and Kailas Behra of one village, Miller, under that Tahsil, Miller. And that land, that piece of plot, Miller, that was acquired by the state government in the year 94, Miller. But no ROR has been corrected. No ROR that has been corrected. Still the land stood in the name of the original landed owners, Miller. In the year 2007, Miller, that is all admitted story of the prosecution. In the year 2007, the present accused person, Miller, he purchased that land from the original tenants, that is original owner, Miller. Subsequently, Miller, under Annexure 5, in the year 2010, Miller, he resold that land in favor of the informant son, victim son, Miller. Then, Miller, he made application for mutation under Annexure 6. Entire mutation process, it was complied with by the Tahsildar. And the RI report is also there. I have annexed everything, Miller. These are all not disputed document. Miller, then that has been mutated under Annexure 7 ROR in the name of the son of the informant, Miller. Then in the year 2015, that is the FIR allegation, Miller, 15, one notice was received, that was received by the victim, Miller, from the Tahsil of Jatani, Miller. Then subsequently it came to notice that land, it was acquired by the government in the year 1994, and thereafter investigation based upon that FIR, Miller, investigation was done by the police. Your Lordship may kindly appreciate, I have extracted the CD, Miller. What is this CD? What is the contents of CD in my petition? I have extracted it, Miller. Your Lordship, I am just reading out, Your Lordship, kind appreciation. That is page 8 of my brief.
All this you want me to discuss in a 482?
Miller, 482, there is no prima facie case. Your Lordship may kindly appreciate what is 120B at least. I am just reading out.
120B, there is some case. As far as 420 is concerned, let the trial court examine.
There is no allegation of cheating. Your Lordship may kindly appreciate.
I am appearing for the opposite party number 2, and the allegation of cheating are there, Miller. And
that's taking care of that. 120B, there is nothing, sir. There is no question to 120B.
No, Miller, there are two persons involved in this case.
Which is the other one? Who's the other one?
Jagabandhu Panda, Miller.
Where is that?
Miller, no charge sheet has been filed.
Where is the FIR? Where is the FIR?
Attorney holder.
No charge sheet has been filed, Miller. I have already submitted the. I have submitted the.
Jagabandhu Panda is there, and other is also there.
Miller, charge sheet.
It's not one person, sir.
Miller, charge sheet.
Intentionally not filed the charge sheet copy, Miller.
Miller, charge sheet. Miller, it has not yet been admitted. Why my learned friend is standing with talking between the argument, my lord. Anyway, my lord. My lord, your lordship, I can appreciate that page 8, my lord. That is the extract of the CDs, my lord. I'm just reading out. Whether any case under section 418 cheating or 415 or 420 is made out or not. I'm just reading out. Your lordship may kindly permit me. After perusal of the documents provided by the acquisition cell, it was clear that Damodar Behera, son of Nata Behera, and Kailash Behera, son of Narayan Behera of Pradhan Sai, received compensation from the government over khata number such and such, Mauja such and such, in respect of the land which is involved. In spite of getting compensation from government, Damodar Behera and Kailash Behera intentionally selling the same to Ratnakar Behera. Ratnakar Behera is myself, Miller, the petitioner before lordship. Then your lordship may kindly appreciate the Supreme Court judgment on that context, Miller. That is quashing of a proceeding also. I'm just reading out your lordship. I'm just submitting. That is Miller. AR 2000 Supreme Court 3241. Yeah. And last para page 7. Para 17 Miller. I am just reading out.
Yes.
Based upon the similar facts and circumstances, judged on the touchstone of the principle noted above, the present case in our considered view warrants interference in as much as the ingredients of the offences of cheating punishable under section 420 IPC and its allied offences under section 418, 423 has not been made out. So far as the offence under section 469, 504, 120p are concerned, even the basic allegations making out a case thereunder are not contained in the complaint. That being a position, the case comes within the first category of the cases enumerated in the state of Haryana versus Bhajanlat, such and such, Supra, and as such, warrant interference by this court, reading the averments in the complaint in entirety and accepting the allegation to be true, the ingredients of intentional deception on the part of the accused right at the beginning of the negotiation for the transaction has neither been expressly stated nor indirectly suggested in the complaint. All that the respondent number 2 has alleged against the appellants in that they did not disclose to him that one of their brothers had filed a petition suit which was pending. Miller, intention at the time of transaction, that is vital, Miller. That is one of the essential ingredients. Then your lordship, I'm just for your lordship kind appreciation submitting 120A, Miller. What is the ingredients? What is the ingredients of criminal conspiracy? Minimum 2 persons is required, Miller.
There are 2 persons.
Yes, Miller. Here the charge sheet has been submitted against me. I have read it, Miller.
FIR is against 2 persons.
No, Miller. FIR is against 2 persons. FIR is against 2 persons. I am just submitting. Once again, I am submitting for your lordship kind appreciation. Here the cognizance has been taken against me alone. Your lordship, I am just once again 35. Your lordship may kindly appreciate. Page 35.
Charge sheet has already been filed against 2 persons.
No, Miller, I am just reading out.
Charge sheet has been filed against 2 persons, sir.
No, Miller, I am reading out. I have 35 is there, Miller.
It's not the charge sheet, sir.
Miller,
page 35 is not the charge sheet.
That is the cognizance order.
Sir, charge sheet has been filed against 2 persons.
No, Miller, that is not there. In the charge sheet, it has been submitted against me alone. And
it's not correct, sir. Your friend on the other side is saying that it has been filed against 2 persons.
Miller, that is not correct. Submit it, Miller.
Anyway.
Keep it on tomorrow, your lordship. Keep it on tomorrow, your lordship.
Not necessary. Not it.
Miller, liberty.
Permitting the petitioner to raise all pleas at the appropriate stage.
I may request, my lord, one thing, my lord. Since the matter of 8 years, my lord, the matter may kindly target it, man.
Yeah. You say it will be open to the parties to request the trial court to expedite the hearing.
Obliged.
17. Item number 17.
Dana appears dismissed.
18.
Dana appears dismissed.
Item number 19.
My lord, item number 19, my lord, I am appearing on VC, my lord. My lord, here we are challenging the cognizance order taken by the SDGM Bolangi, my lord. My lord, under section 498, 323 and 307, my lord. But the present petitioners are the old father-in-law and mother-in-law of the accused person, my lord. There is a matrimonial dispute, my lord. My lord, there is no ingredient. The allegations are omnibus in nature, my lord. My lord, there is no ingredient of 498A, 323 or 307, my lord. Lord,
Permitting the petitioners to raise all pleas in the appropriate stage. The petition is disposed.
Item number 20.
Item 20, Lordship, infructuous.
Infructuous disposed.
21.
Item 21 is not permitted to raise all.
Permitting the petitioner to raise all pleas.
Item 22.
None appears dismissed.
Item number 23.
None appears dismissed.
Item number 24.
Quashing of the interrupt criminal proceeding, the petitioner has prayed for. This is a case under section 138 of NI Act, my lord. The notice which has been issued, the check has been issued by the firm, my lord. And no notice has been given to the firm under section, as specified under section 141 of the NI Act, my lord. Only your lordship may see page 12. It is Rudra Enterprises and proprietor has issued the check, my lord.
Proprietor, sir.
Yes, ma'am.
Not firm. Then you can raise all these pleas, permitting the petitioner to raise all pleas in the appropriate stage. Petition is disposed. All right.
Item 25.
None appears dismissed.
Item number 26.
None appears dismissed.
Item number 27.
Permit to withdraw, lordship. Permitted to withdraw. Dismiss this petition.
Item number 28.
May I proceed? Petitioner is though victim, he has been arraigned and accused in the FIR at Annexure 1. The FIR at Annexure 1 lodged in the year 2015. Until date, it has not final form has not been submitted.
That's
So
because you have filed this petition.
Pardon, Your Lordship?
That is because you have filed this petition.
No, there is no order of stay or anything, Your Lordship.
So that's fine. Then it will happen then.
Your Lordship, may kindly see page 15, Your Lordship.
Yes.
This is a bail condition where I have to appear in each Monday before the IO.
Right.
This is my
This is all you can apply to that court for modification of the
Lordship,
Here you are asking for quashing. There's nothing to do with bail.
Lordship, I have filed this application in 2019. We are in 2023. I have to take instruction whether in the meanwhile charge sheet has been filed or not.
No problem. Permitting the petitioner to raise all pleas.
I'll withdraw this petition seeking at liberty. If the cause of action still persists, Your Lordship.
No. You say permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed. All right.
Item 29.
May please, Your Lordship, I mean virtual mode, Millers.
Yes.
Here, Millers, a complaint case was filed challenging the bouncing of a check. But in the complaint petition, there was a mistake in the date. We wanted to amend it. The amendment was rejected on the ground.
No provision for amendment and all, sir.
Your Lordship, kindly see your Your Lordship, kindly turn to page 12.
Yes.
What is the mistake, Your Lordship, kindly see? Page 12 is the check, Millers.
Yes.
Check which dated 39/2016.
Yes.
The return memo is here, Millers. It is dated 9/12/2016.
Yes.
In the complaint petition by mistake for encashment on 39/2000, though the check was presented on 8/12/2016. That is by it's instead of there is a mistake in the date only, the genuine date, Millers. There is nothing, it neither changes nature and character, but in the ground that nature and character, they have rejected it.
There's no provision in the CRPC to amend a complaint, sir. Show me one provision, Mr. Das, in the CRPC that we can amend a criminal complaint.
Your Lordship, kindly see page 24. I have cited a decision, next page. I have cited a decision of Bombay High Court, Millers, wherein the Honorable High Court of Bombay have held that amendment in the complaint petition is permissible.
Anyway, that all depends on. There is no provision in law, sir. There is no provision in law.
But the question is that a genuine mistake, Millers.
No.
Genuine mistake with the man suffer, he has 25 lakhs, he has rent.
No. After the trial goes through, you can't amend.
It has not, trial has not started yet.
No. During cross-examination, you pointed out the merit of the prosecution during cross-examination. Yes.
No, Millers, I have never.
Yes.
Your Lordship, I kindly
Just come to para 2, sir. That gives you the facts.
Yes.
Following the complaint petition, the date was mentioned in the affidavit, which was filed as examination chief at a later date when the complainant came to know about the mistake, he filed a petition.
Yes, ma'am.
After hearing the objection advanced by the accused. So that must have happened during the cross-examination.
But it is a genuine date, ma'am.
No.
The date documents are there. If the documents speak otherwise, can it be rejected?
No, it's okay. You see, the challenge in the present petition is to a judgment dated 10th May 2018 passed by the learned sessions judge. Denkanar, dismissing criminal division number 5 of 2018 filed by the present petitioner against an order dated 6th February 2018 passed by the JMFC Denkanar in 1cc case number 27 of 2017, declining to permit an amendment to the criminal complaint under section 138 of the Negotiable Instruments Act. Paragraph. The amendment was sought on the basis that in the criminal complaint, the petitioner inadvertently mentioned that the check had been presented for encashment on 30th September 2016, when in fact it was presented on 8th December 2016. Stop. This was sought to be projected as a mere typographical error. Paragraph. The fact remained that after the affidavit had been filed by the complainant and when he was being cross-examined by the counsel for the accused, this basic defect was pointed out, and thereafter the application was filed. Paragraph. As rightly noticed by the learned sessions judge, allowing the amendment would in fact cause very serious prejudice to the accused.
Can I so one thing? That document has already been exhibited. Exhibit 2.
That's all.
Page 12 minutes, that document has already been exhibited.
All right.
Genuine document has been exhibited.
Yeah. The court therefore is unable to find any error having been committed either by the JMC or by the learned sessions judge in rejecting the plea of the petitioner. Paragraph 3. Petition is accordingly dismissed. Yes.
Item number 30.
Item 30, your lordships, on behalf of Mr. S.R. Mahapatra, permitted to withdraw this.
All right. Dismissed is withdrawn.
Item 31.
My lord, item 31 not pressed.
Not pressed, dismissed.
Item number 32.
None of this dismissed.
Item 33.
33,
None
my
of this.
lord, permitted to be withdrawn. Permitted to be withdrawn, my lord.
All right. Dismissed is withdrawn. All right.
Item 34.
34 may I please permitted to withdraw, my lordship.
Dismissed is withdrawn.
Obliged.
Item number 35.
That's on behalf of Mr. Aniruddha Das. There is an application under section 457 of CRPC for release of vehicle. So the vehicle is still in excise department, Pankos excise department, custody of Pankos excise department. Covered by your lordship judgment also, that is Ashish Ranjan Mahanti versus State of.
So we'll say notwithstanding the impugned order, you can move under that.
That's it.
You say it's clarified that notwithstanding the impugned order dated 18th of August 2017, passed by the SDJM Pomposh, it will be open to the petitioner on the strength of the judgment of this court in Ashish Ranjan Mohanty versus State of Orissa.
And
It's reported or not?
Let's see, reported. 2022-85 volume 85 OCR. That is page number 705.
To renew his application afresh before the SDJM Panposh for release of the vehicle in question. Such application will be considered on its merits in light of the aforementioned judgment of this court. The petition is disposed of. Just the citation. Just write down the citation.
Item 36.
My lord, the petitioner and the informant have compromised the case, my lord. And I may be permitted to edited this compromise with the land and lord.
All right, permitting the petitioner to resolve peace of the property.
Item number 37.
I want to permit my lords.
Permitting him to resolve peace. All right.
Item number 38.
38, your lordship, no instruction is
No instructions dismissed. All right.
Item number 39.
None appears dismissed.
Item number 40.
Just put this IA number and none appears dismissed.
41.
None appears dismissed.
Item 42.
None appears dismissed.
Item number 43.
Same order.
Item number 44.
Same order.
Item 45.
Put this IA and say none appears dismissed.
Item 46.
46 lordship, no instruction.
No instructions dismissed.
Item number 47.
None appears dismissed.
Item number 48.
Lordship, item number 38 permitted to raise all the points.
Right. Permitting the petitioner to resolve this.
Item number 49.
None appears dismissed.
Item number 50.
None appears dismissed.
Item 51.
Same order.
Item number 52.
Same order.
53.
May please, your lordship. In the case, my lord, the petition prayed for quashing of the FIR, my lord. All of the petitions are the member of two national political party, my lord. Being the member of national political party, my lord, they have demonstration. They have held the demonstration, my lord. And the FIR lost, my lord, by the police officer, my lord. Despite the demonstration, for the demonstration, the intimation given to the police, my lord, and on the day of demonstration, they have handed over the demand charter, my lord, which is annexed here, my lord. And despite all the peaceful demonstration, my lord, the FIR lost against the petitioner, and FIR itself discloses no offense, my lord, no cognizable offense, my lord. And the entirely covered under the Bhajanlal case, my lord. Your lordship knows the what principles led by the Bhajanlal case by Honorable Apekshur, my lord.
So if you barge into a police station, push the mobilized police officers and personnel, you're asking for trouble.
Lordship,
you barge. Just read the last 4 lines in page 18. This is FIR. All of a sudden, just see that last 4 lines, page 18.
18 is the report, my lord, but the FIR is started for 19, my lord. FIR started from 19 and 20, my lord.
Sir, para 12 says first information contents. Correct?
Contents, my lord.
Just read that last 4 lines. All of a sudden,
that contents are registered by the IAC, my lord, but the FIR itself is my lord started at 19, my lord.
It's okay, sir. What the IIC is registered is also part of the FIR only.
But
that's a registered FIR.
Absolutely.
Just read that. Just read last 5 lines of that. All of a sudden.
That on duty police officer try to specify them, but
they are reading out the earlier sentence very conveniently. All of a sudden, just the previous sentence.
All of a sudden. I got it. The above accused members of the unlawful mob tried to bend into the Chauliaganj police station.
Barge into the. BARGE.
Barge into the Chauliaganj police station, pushing the on-duty mobilization police officers and personnel, my lord. Thereafter, the on-duty police officers tried to pacify them, but the above agitation.
It's all right, sir.
Provocations. But in the FIR, my lord, FIR itself start from the page 19, my lord, lost by the police officer, my lord.
Yes.
No such contentions in the FIR, my lord.
Again, read the same lines in top of page 20. Same lines.
Second line, my lord. Page 20, second line, my lord. But no such offense, no such activities done, my lord, because police obstacle them. They have handed over the demand charter. Everything recorded in the camera, my lord. And now what happened, my lord, after
the demonstration held, my lord. There are the FIR laws against numbers of people. Those are including the leaders of the district, my lord, the political party. Now the case is, my lord. Now, whether the political people have right to protest, which is coming under completely Article 19, my lord.
So let
expression of freedom of expression.
Argue all that, sir, in the trial court. Yeah.
But they are not in bail.
Argue with heart's content.
Lordship, they are by interim order, by virtue of interim order, no course of action. They are not now. They have not moved for the bail, my lord.
So now everything will happen, sir. We'll vacate the interim order.
Lordship, what if your lordship, the DJ to raise all this issue before the trial court, I do not know in which stage case. Your lordship may direct the petitioner to surrender religion bail, my lord, by exercising the 482, because no such offence, my lord. Whatever the offence, your lordship, or the laws in the FIR, my lord, your lordship show see the offences.
You're Mr. Mahapatra, right?
Lordship.
This practice of granting bail in 482 has to stop, sir. 482 is not meant for bail.
I am not seeking the bail, your lordship. I am seeking in case your lordship directing to the petitions to raise all these issues. I do not know in which stage the case is. Therefore, I am seeking your lordship's inherent jurisdiction under 482 to release and bail on surrendering, your lordship. I am not seeking the 438 bail application, your lordship, because after 3 years. These people, political people, now they have to lose another forum, my lord. And no such offence made out prima facie, no such offences disclosures in the FIR, my lord, except that one line, my lord, what the lordship just identified during the course of hearing, your lordship.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of, the interim orders vacated. A copy of these orders should be sent forth with the court concerned. All right.
Item 54.
Lordship, one line, if the surrender move for bail, there shall be...
There are enough provisions in the CRPC. Sorry.
Then your lordship may permit...
I need not to educate you, sir. You are such a learned counsel. You know how to advise them.
My lord, sorry, my lord, this case has foisted by the police personnel only to suppress the voice of the democracy, my lord.
Good, sir. Your voice has been recorded now.
Counsel, your lordship.
All right.
Permitted to withdraw, my lord.
No, that's all right. This 54. No, 53 is okay. That's order.
Withdraw, my lord.
No. We have passed the order. Right.
Item 54.
None appears dismissed.
No, 54 and 55. Lordship need to be for release of vehicle. It should be converted to criminal revision.
All right. Counsel to the petition. You file a fresh criminal revision, sir. Counsel to the petitioner seeks leave to withdraw these petitions with liberty to file appropriate petitions in accordance with law. Disposed of is withdrawn with liberty is paid for. All right.
Madam, your lordship, 53. One liberty, can I pray, your lordship, to approach for another forum under participatory?
Not necessary.
Because suppose I will move for the 438 at this stage, my lord, then that court may...
Nothing will happen. Right.
That liberty, your lordship, only that liberty.
No, sir.
So avail other remedies available.
No. Sorry. Yes.
Item number 56.
56, my lordship, and for petitioner seeking causing of FIR, which are under FIR, there are offences are 417, 294, and 506. Earlier, my lord, for a moment, kindly see the FIR. Though not a single line has been constituted the offence against the petitioner. Earlier, the informant lost all these FIR against the petitioner and his family, which they all have acquitted by trial on a trial court. I have annexed the order sheet, my lord. And just to implicate the petitioner and to harass the petitioner, the informant lost this FIR again, my lord, with those offences. Not a single evidence is there to constitute the alleged offence. The brief of the informant has been one-sided love with the petitioner, as the petitioner is going to marry. Falsely, she tried to implicate the petitioner in these offences, to harass the petitioner only.
What's the current status? No stay was granted by this court. What has happened in the lower court?
Lower court, I have no information whether the charges has been submitted. But what about the order sheet that annexure 2 of 20, page number 20, my lord?
That is as far as the earlier judgment is concerned.
Sorry, my lord.
Annexure 2 is the earlier judgment.
earlier offences are also against the petitioner and they all have acquitted, which is page number 19, my lord.
Right.
And there are a number of reportable Supreme Court judgments. If the allegation of offence are not constitutional FIR, the FIR should be quashed, my lord.
No, that's true, but nothing, there's no stay here. There must have been some development in the lower court because there is no stay here. So you can raise all these.
May I pray for short adjournment, my lord?
Not necessary.
So I have
Permitting the petitioner to raise all pleas at the appropriate stage.
at the time of
Petitioner's disposal. Correct.
Note 57.
I have challenged the FIR, my lord, and the proceeding. In
Yes.
the meantime, my lord, charge has been framed, my lord.
Yes.
And we have, so I want to seek, my lord, this, withdraw this application and to liberty to raise all.
Correct. Permitting the petitioner to raise. Correct.
And liberty may be granted, my lord.
No, we have.
To challenge the charge, my lord.
That you will anyway do, sir. Please. Yes. We don't need
I have
liberty.
filed a discharge petition.
You don't need liberty for that, sir. Please.
Yes.
Yes.
Obliged.
Item 58.
None appears dismissed.
Item note 59.
Question of order about taking cognizance dated 29/11/2016 as well as entire proceeding. And Lord, matter has already settled by filing a petition, joint petition under section 13B before the London Judge, Family Court Judgepur.
Where is that? Where is that order? You only filed a petition.
Order, a certified copy of the order annexed to order 5. Order has already made.
All right.
Annexed to page 19.
All right. You say annexure 3 is the order. It's a judgment dated 2012-2018 passed by the Family Court Judgepur dissolving the marriage between the petitioner number petition number 4. Yeah, petition number 4 and opposite party number 1. There is no opposition to the prayer for quashing. Accordingly, just take from the prayer clause. All proceedings consequent hereby quashed.
Item number 60.
My lord, here the petitioner has filed this application for quashment of the entire proceeding. My lord, here what has happened? There was a lease deed entered between the petitioner and the Tahsildar from 2015 to 2020. And my lord, I was extracting the minor minerals pursuant to Annexure 1, my lord. Now they lodge an FIR against me saying that you are illegally transporting sand out of the state. My lord, I am not an illegal transporter. I am by virtue of the lease agreement, I am doing the transporting business. The very basis of the filing of the FIR is not there, my lord. There cannot be an illegal transportation unless I am covered by a lease agreement between the Tahsildar.
Why not, sir? If you will mine in excess.
My lord, there is no.
If you mine in excess.
No, my lord, there is. Your lordship may see the FIR. I am as within the limit of my transportation as per the lease agreement.
That you point out, sir, to the court, permitting the petitioner to resolve pleas at the appropriate stage.
My lord, here the very basis is not there.
Sorry. You can point that out, sir. Yes.
Then your lordship may grant me that leave that I can change.
That's right. That's right. Permitting the petitioner to resolve pleas. Right.
Item number 61.
None appears dismissed. This IA. Just put down the IA.
62.
None appears dismissed.
Item 63.
None appears dismissed.
64.
None appears dismissed.
Item number 65.
Same order.
65. My lord, this petitioner has already been punished for the self-same causes of the FR. The informant of the first FR is also senior of the second FR. Self-same cause of action, there are two in the two police stations, there are two FRs. Man. In the first FR, he has been already punished for the same offense. Man. So the second proceedings is pay for cost as per section 300 of CRP's. There is lordship kind see Annexure 1, there is the offense 420, 406, 506. These are offenses, my lord. And Annexure 2, I have been already punished, my lord. 5 years in the custody, my lord.
No. Offenses meaning same complainant or different complainant?
Same complaint, my lord. My lord, kindly see, running
Who's appearing for the complainant?
My lord, running page 15, my lord.
Sir, who's appearing for the complainant?
Running page 14, my lord.
Mr. Lakshminarayan Patel.
My lord, Sabita Martha.
Counsel, sir, who's appearing for the complainant?
Complainant Sabita Martha in first FR, my lord. Running page 14. Running page 14.
You're not able to hear it.
Running page
Am I audible, sir?
Yes.
I'm audible.
My lord.
I want to know name of the counsel for complainant.
That is Sabita Martha.
Counsel. ଓକିଲ କିଏ?
Makan Sahu.
ଆରେ ଆପଣ ନୁହନ୍ତି ଅପୋଜିଟ ପାର୍ଟିର ଓକିଲ କିଏ ଜାଣିଛନ୍ତି କି?
There is, sir. There's somebody who's entered appearance. Mr. Lakshminarayan Patel has entered appearance. Just for your information, you should also know. Is the cause list reflecting his name? It's there in the cause list also. You've not seen the cause list. You see, one Mr. Lakshminarayan Patel has entered appearance for opposite party number 2, but he's not appearing today. Registry will inform him to remain present on the next date. Interim order to continue. List before the roster bench. 10th May.
Item 66.
Please, your lordship. Lordship, we are challenging the order of cognizance. The co-accused persons who has implicated the petitioner in this case in way of co-accused statement after facing trial, White Sessions case number 76/35 of 2004 in the Court of Law and Assistant Sessions Judge Dharmagar have been acquitted by judgment dated 23/5/2008, and during the trial, none of them have supported the case. Under such circumstances, as at present, no prima facie material is available against the petitioner, your lordship.
It's okay. You can
Here
raise all these
for-
pleas at the appropriate.
Here we are praying for the petitioner pending the case.
Sorry, where is
pending
the
before
order?
Lorna James.
This order taking cognizance, which annexure is that? You're seeking quashing of an order dated?
Yes, your lordship.
2nd January 2004. You're challenging an order dated 2nd January 2004.
Your lordship, that is the Sessions case number 76/35 of 2004.
Just come to your prayer clause, madam.
Yes, your lordship.
Read that.
The cognizance dated 2/1/2004 passed in city GR case number 214A of 2003.
Where is that order?
We are praying for squashing that order to be kindly be squashed.
Where is that order?
Sorry.
Where is that order?
Where is
Annexure.
Annexure. Your lordship may kindly see. Order number 23 dated 2/1/2004, the last pages.
This case is filed in 2019.
I know. I don't know what
15
15 years what they were doing.
Charge sheet has already been submitted.
Submitted long ago. By
Section-
now, everything must be over.
Current instruction ଅଛି କଣ stage of the case?
You see, it is. There's no explanation
There is no instruction.
for
your lordship.
counsel, but the petitioner states she has no instructions when she's asked how an order dated 2nd January 2004 passed by the JMFC Jaipatna in CTGR case number 214 bracket A of 2003 is being challenged in 2019. Clearly, the matter is a stale one, and the court will not interfere at this stage. The petition is dismissed. Interim order is vacated. A copy of the order be sent to the concerned court for it.
Item 67.
None appears dismissed.
Item number 68.
68, my lord, to your lordship, my lord. But in this case, what happened initially, FIR has been registered. Police submitted final report as mistake of fact, my lord. Subsequently, FPP filed a petition of protest, and a London magistrate to taken cognizance, issued warrant, and 83 process simultaneously before issuance of summon, my lord.
All right. When will you appear? Permit the petitioner will appear before the concerned court on 1st May 2023 and thereafter seek appropriate orders in accordance with law. Till then, the NBW will not be executed. No further directions are called for at this stage. The petition is disposed of. All right.
Item 69.
Appear and release on bail.
That all you do, sir. Right.
97 case, my lord.
All right.
69.
My lord, I am for the bank, my lord. Opposition.
69 liberty may be granted to raise all the pleas.
Permitting the petitioner to raise all pleas. He put down his appearance for the bank.
Presence may be recorded.
Item 70.
None appears dismissed.
Item number 71.
Same order.
Item 72.
Memo taken on record. No instructions dismissed.
Item number 73.
None appears dismissed. Yes, Mr. Banda.
My lord, here the petitioners have challenged an order of the learned special judge CBI, Bhubaneswar at Annexure 3, my lords. The relevant order is of dated 15/1/2019 at page 41. My lords, here what has happened is your lordship may look at page 26. At page 26, this is the final report submitted by the CBI against the petitioners. The IO writes, it is to be mentioned that both above named accused were arrested in course of investigation, forwarded in custody to the Honorable Court, subsequently released on bail by the Honorable Court. Since both accused are not sent up for trial due to reasons mentioned above, they may be discharged from their respective bail bonds. Bank has conducted departmental inquiry against both accused, and he has stated the punishment imposed. And its prayer is that the final report may be accepted, my lords. Now, after this final report was passed, my lords, the learned special judge CBI kept the matter pending until 15/1/2019, when by the impugned order, my lords, the court writes at page number 43, my lords, like this. Your lordship may see page 43.
Yes.
Second paragraph, he writes, during course of investigation by CBI, it reveals that accused so-and-so was working as...
Who is for CBI here?
Mr. Sarthak Naik usually appears.
No, he's
Naik.
not here. He's not here. I will
All right.
inform.
Mr. Naik, who appears for the CBI, is not present today. The registry will inform him to remain present before the roster bench on the next date. Interim order to continue. List before the roster bench on 16th May.
Lord, 16th May, I will not be available. Can it be after the vacation?
All right. 6th July, sir.
74.
None appears dismissed.
Item number 75.
Please, your lordship. On behalf of Amita Tripathi, my lord, the petitioner has filed this application challenging the order of cognizance dated 24/2/2019 passed in 1cc number 4/19 pending in the file of learned STJM Baleshwar. Complainant has filed the complaint petition Ellis Commission of Offence 436, 427, 379 along with other offences. But after perusing the statement recorded under section 200 of CRPC, complainant ordered the learned magistrate to cognizance under section 427, 341, 506. Charge sheet submitted. The fire brigade came to this spot and extinguish the fire. In this regard, the station officer has given a certificate.
Madam, all pleas can be taken at the appropriate stage. Say permitting the petitioner to take all pleas at the appropriate stage before the trial court. The petition is disposed of, the interim order is vacated. Right.
Item 76.
None appears dismissed.
Item number 77.
77 lordship, no instruction.
No instructions dismissed.
Item number 78.
My lord, one time the conducting lawyer is severely ill, my lord.
What is the matter about, sir? Let us just see. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of, the interim order is vacated. Let's put down his appearance.
Right.
Yes.
Item 79.
May I please, Your Lordship? Your Lordship, case and counter case, Your Lordship, matter is amicable settled within the parties, Your Lordship. Your Lordship, order dated 5/8/2019, Your Lordship.
Who is appearing with the other side? You're in this matter, no?
No, he is not.
Where is the compromise petition, sir?
Your Lordship, I have mentioned in my petition, Your Lordship.
No. There's no affidavit of the other side.
No, till today, he has not.
Then you raise this before the trial courts. Permitting the petitioner to raise all pleas at the appropriate stage.
Item number 80.
Obliged.
None appears dismissed.
Yeah. Item 75, Mala. I am appealing for the opposite party 2 to 9, Mala.
All right. Just put down his appearance. All right.